Yes.
This for cancellation of bail.
Item 1 and 2 will come back after the fresh matters. 1 and 2 will come back after the fresh matters. We'll do the fresh 16 and then go to 31, come back to 1 and 2.
This is between two brothers litigating for 20 litigations. I have a school, I filed an appeal. The High Court says your appeal is not maintainable. How is the High Court concerned?
No, Mr. Rogi, completely unauthorized. You tell us how it is.
I have a right of regularization. I filed.
School has a problem. You see, in Kumbakonam in Tamil Nadu, I remember 16th May 2004. Any of your Tamil Nadu colleagues will tell you.
Yes.
There was an accident in a school. A number of children lost their life in a fire accident. So, nothing of unauthorized will be permitted. We are very, very clear on that.
Just bear with me. I filed an appeal. The High Court, in a writ by the brother who's litigating with me for the last 20 years. The High Court says your appeal is not maintainable. Why should the High Court say that?
No, your appeal under 80A, no?
79.
79. That is for, now you are trying to regularize this construction. No, that can't happen. The appeal is in the event of a rejection of a sanction plan.
But we get this back.
No,
when you apply for regularization,
yes.
you are wanting ex post facto sanction.
No, this you show how a building is regularized. No, you see.
I can keep it sealed, if necessary. If you can save the building by ex post facto regularization.
No, school, particularly when we saw it as a school, any of your Tamil Nadu friends will tell you. Remember the Kumbakonam tragedy? 16th July 2004. Still, screen in the memory. So, it was on a story with no fire exit, etc. How many children? 93 children, I think. We will be failing in our duty.
I respect this. Against the order against which I filed an appeal, the order itself says.
No, have you moved the High Court saying my appeal is not decided? This is on.
Yes.
This is on Muruganandam's writ petition for its decided.
Earlier, my writ was disposed of by saying that the appeal may be heard. Meanwhile, in this case.
Yeah, you pursue whatever remedy available to you, but this order we will not interfere because that we don't know what is the position there.
I agree, but not in this order, it has foreclosed my appeal. At least you also may say that. Kindly turn to page 5. This is my problem. I have no other issue. Turn to page. I have two submissions. Page 5, paragraph 4. This court is of the opinion that the appeal is not maintainable. Why should the High Court not give a declaration? Number one.
No, to issue a revised plan in respect of an unauthorized construction already made. Let us see 79 and let us see how ex post facto permission.
Respectfully submit. The High Court, sorry.
Already is passed.
No, yes, my brother is right. Just read the next sentence, section 79.
Yeah.
Appeal is entertained. Any person agrees decision
49 may appeal to an authority as prescribed.
Yeah.
Now, the title may be wrong or right, but there is a.
No, you just show 79. How it is maintainable.
79.
Yes.
They just read it out or hand it over.
It must be on record somewhere.
The Lordship may see it from here.
Yeah, I'll just see. You just read it. You read, Mr. Rod. You read it.
I'll read it from here.
All right.
Document.
All right.
Also said you may file an appeal under this. Now kindly see this.
Yes.
Appeal to prescribed authority. If any person is aggrieved by an order under section so and so, he may make an appeal to the principal secretary so and so.
Now let us go to 49 and 54 and come back to subclause 2 later.
Yes.
Yes. Application for permission.
Except as otherwise provided by rules, any person not being a state government or authority intending to carry out any development in land on or after the date of publication of the resolution under subsect clause 2 of section 19 or notice in the Gazette under section so and so shall make an application in writing to the authority for permission in such form contains such particulars accompanied by such document prescribed. The appropriate authority shall, in deciding whether to grant or refuse, have regard to the following matter: the purpose, suitability,
Correct. This is when you apply. Then come to 54 also. 54 subsection 1.
49 will also
After it is brought down, if it is your land, you appropriate application for sanction, you make just see 54. Power of revocation. Nothing, it doesn't apply at all.
I am kindly just see. Kindly just see. Under 49,
Yes.
there is no bar that you will not apply for sanction if it is already made.
No. Its position is very, very clear. These are matters where you are aggrieved by the sanction, non-sanction, partial sanction. But when you just erect a building and you attempt is to seek regularization, this is not the provision.
Also, in other words, a sanction.
No, Mr. Rodgi, this is extremely contrary to public interest to have a school or any inhabitation in that building. Brother, please.
Probably impression was carried by the petitioner that the court observed that appeal is not maintainable. Only that first sentence. But the court says not maintainable if your plan is waiting the decision. Once the decision is given by the authority.
I respectfully submit. Was this the issue before the High Court? Why should the High Court is not advisory jurisdiction? High Court was just
the authorities who are to themselves demolish. It's going on since 2015. Don't do anything unless public interest spirited citizens go. How will the interest of children be fulfilled?
No, brother, that 10 litigations, policies of BIL in accord with Chauvel's case.
High Court has examined it, Mr. Rodgi. We are not inclined to.
Kindly will not grant me reprieve of at least 2 or 3 months. My appeal may be
No, you have been given till end of May. Tamil Nadu schools open in June. Unlike here, when I went to school, we will close in April and June we will begin. Here you begin in April and then continue in July.
Lordship says my appeal may be heard, uninfluenced by this at least. Otherwise, appeal foreclosed. I have to bring it down.
Yes. Ms. Pritika, anything in the second matter on road, we have seen that matter. Anything, it's all the same. You have now blocked that road and constructed. Yeah, you want to say anything?
Just give me 2 minutes.
Yes.
My lords, may kindly have the single judge's judgment at page 289.
Yes.
There is no dispute about the fact that that piece of land is mine. The
Yeah.
patta is in my name. My name. The High Court says that irrespective of the fact that the land is yours, you are now the trustee of the land. So that, my lords, there is nothing. Please have page 289.
You come, show us the impugned order after you show us this. We'll see.
But the impugned order.
No, you show this first and then you go to the division bench. We don't want to foreclose you just like that, but show us 289.
289.
All right.
Single judge is
Yes.
also upheld by the.
Yes.
Let's the last 4 lines of the first paragraph.
Yes.
The 5th respondent is the custodian of the said road, though the revenue record stands in the name of the 7th respondent.
Yes.
Further, as the 7th respondent, while obtaining building permission and approval, had shown the 40 feet road as public road.
Yes.
Pause here.
You showed it as a public road.
Actually, I'll take my lords to the application.
No, you read it fully. Yeah.
And thereafter, he cannot use it as his private property and cannot prevent others to use as road. Now, may I just pause here for a minute? The applications are on record. I did not show it as a public road. I showed it as a road to show access to my school. So this itself is...
No, you just come to the impugned order. You want to say something?
The last 3 lines. In view of the law laid down by the Honorable Supreme Court, the original owner of the layout land on reservation of portion of the layout land for public purpose ceased to be its owner.
Okay, come to the impugned order.
My lords, may I have the impugned order at page 1? Yes. The impugned order actually itself doesn't say anything at paragraph 3, page 3.
Yes.
After having obtained a planning permission.
Yes. Showing the portion of road.
Blocked a portion of it and converted it for their private use. Now, this is incorrect because my case is that my land is where the road ends. My land is not a part of the road. That I am the owner of the land is not disputed.
Who are you for?
just one, 0.1 is over.
That's over now, Ms. Pritika. When Ms. Pritika is fully convinced that totally charged she'll be, that's over now. She is across the public road. And I know, but she is over now.
And may I just also just show the site plan? Because
Yes.
this is absolutely incorrect. There are two things. One, my approval did not mention it as a public road. It shows it as a road. That's number one. Second, the writ petition itself was not maintainable because he was claiming easementary rights on that. So he has to file a suit. Now just have the site plan for a minute. My lords, may kindly have that. Page 314. And this is a site plan which is issued by the city surveyor. My lords, see the yellow portion that is 21 by 11. That is abutting the road which is in blue. So my land has nothing to do with the road. The road ends at my land. And he was claiming...
Yours is 3-1?
3-1. Mine is 21 by 11, the yellow...
21 by 11. Page is 3-1. For 21 by 11, just tell us where it is.
The yellow portion. It says 21 by
No, yellow, even in the computer it is black and white. It's the color, the shaded portion, no?
It's 2-1. It's the...
Yes, I have seen the 21 bar 11, the small...
So
yeah.
abuts the road. My land is not part of the road.
That's okay, that's okay. No. Yes, quickly.
One is the building construction is not unauthorized. It's only one floor that is done. That's the first thing I wanted to just point out. And in fact, I am permitted to make 2 more floors. If you look at the FSI, etc. If they demolish this, I will
Do it right, royally, regally, frontage, sidage, ground, playground, road, so that children, particularly for nothing doing. No. You see, this is all, how many children, how many classes? 2,000 children, can you imagine what will happen? Having heard Mr. Mukul Rothki, senior advocate, and Ms. Nina Nariman, as far as item 3 is concerned, we find no merit in the special petition. The special petition is dismissed. 3.1, having heard Ms. Pritika Dwivedi,
that becomes
having heard Ms. Pritika Dwivedi, learned counsel appearing for the petitioner, we find no merit in the special petition. Special petition is dismissed. Now you have been given time till May. Have you set out anywhere that this evaluation is to take place in June, hence extend in 3?
I am one of the evaluation.
170. Yes.
In the school just evaluation camps and answer sheet collection points. And
All the results will be out by then. Nothing will be done in June. It's all over now. It's all. You have been given time till May. I saw the. Is there any evaluation happening there now? Nothing is nothing.
Not completed, your Lordship. Sorry. Completed. 28 was completed.
I'm the school.
Anyway, even for the evaluators, we have to take care of their interest also. All of them must be teachers. So no merit. No. Sooner it is brought down, the better it is for all of us. You just ask your friend to brief you on the Kumbakonam. Permission for SLP appear and argue in person. Nobody argued in person.
Your Lordship, myself, Your Lordship,
All
the
right.
caveator, Your Lordship.
I thought you were a lawyer with all your black coat and
Your Lordship, actually I am an advocate in this case.
permission to argue in person to the respondent is granted.
Yeah, please, Manoj. Here, Manoj, in 1987, this plot in question was allotted to us. Thereafter, the matter...
One second.
Yes, my lords.
One is where Justice Sundaresh was a party and one Justice Dulia was a party. Yeah, it's marked here, is it? Bench
Yes,
came
my
by
lords.
marking
The
here.
notice has been issued from by this court, my lords.
By this court, is it?
Yes,
All
my
right.
lords.
You can hear it. There is 2 orders. 3 orders you are complaining of contempt.
Yes,
Of them, 2 I find judges are available.
yes. But this matter was the contempt jurisdiction was.
No, but sister has issued notice. Contempt, na? Your case is that earlier order itself took care of the NOC and according to you share transfer also, but he says no, as far as share transfer is concerned, it was not dealt with. Now question is whether it should be dealt with by the same bench.
I will just point it out, my lords. Pardon me for this, my lords. The first round of litigation, when the first order was passed, my lords, at that point of time also the very same issue was there in before the honorable court, my lords, when Honorable Justice Cole, as his lordship was then was, my lords, had passed the order accepting my special leave petition. Thereafter, my lords, my lords, they did not register the plot in my name. I filed a miscellaneous application before this court, my lords. Then they appeared, my lords. Notice was issued on a miscellaneous application. Then they said that all right, we will do the conveyancing of the property, my lords. The conveyancing was done, my lords. The land was registered in my name. Thereafter, my lords, there is a process of online verification of the certificate, which is a no due certificate. Now, when we approached them for verification of that certificate, they said, no, we cannot do it. We'll reject it because there are dues of 2011. Now, Lordship may just have that online registration certificate, my lords, which is at page 25.
No, you convince us on this aspect of the matter.
I will do that. I will do that.
No, that is
The shareholding. Yes.
when your Orient, 79% shareholding has changed hands.
Yes.
Now, according to them, under 2015 scheme,
ENP policy.
there has to be a payment for transfer charges.
Yes.
What is your stand on that? Have you complied with that?
My lords,
Was it expressly dealt with in the earlier order? If so, how do you get around that scheme? We want clear answers.
I will do that. I will. Lordship may just have page 25 first. My lords have it.
One second. Yes,
Lordship, see bottom of the page, last 2 lines.
one second. Yeah.
Their case is that there are dues with respect to change in shareholding, which was done in 2011. Now, my lords, we see plot cost default as on 8/11/2022, 0. Enhanced cost default as on 8 November 2022, 0. Other dues as on 8 November 2022, 0. Now, my lords, when I approached them, my lords, then they passed an order which is at page 9 of the additional affidavit.
When did they come to know of the transfer?
They say that when they stepped into the shoes in 2020, then they came to know.
Actually, then how could the 2000
Yes,
this notice deal with that?
yes.
So then,
Now, Lordship may see, my lords.
how much is the due for transfer?
My lords, 72 lakhs. I have paid it under protest today because your lordship clock is ticking, my lords, and I have to complete the construction by July of 2025.
So what is the problem now that he has paid under protest? What is the
So they have to refund it because it's not. I am not liable to pay. I am not liable. That's my whole point.
Yes, there is no problem in construction now.
No,
It's going on.
it's going on.
July is the deadline.
Yes, yes. I have to complete that.
Only on
Page 9.
only on refund now.
Yes.
How can you argue in a contempt that?
No, no, I have paid it while the matter was pending before this court because they raised a demand on me while the matter was pending. That's why my last page, my lord, Lordship may see, I have categorically stated we await the decision of the contempt petition number 886/2020, which is a current contempt petition before the Honorable Supreme Court of India. Accordingly, either this demand shall be treated as
Which page are you reading, Anubhav?
page 13, please. Page 13 of the last additional affidavit, Miller's application on behalf of the petitioner. IA, that's an IA, page 13.
Additional affidavit. That is short reply, is it?
It's called the application on behalf of bring on record additional documents.
Yes.
13, Malad.
13.
Yes. Last.
That is annexure 4 of that.
So here, last line, we await this 72,91,659 was the demand raised. We pay this demand and we write it here. We await the decision of the contempt petition number such and such before the Honorable Supreme Court. Accordingly, either this demand shall be treated as paid in full and final settlement, or it shall be refundable to us with interest till the date of full payment. Now, Mullahs, what I wanted to show you to your lordship was page number 9 of the page number 9 of the first additional affidavit, where they reject my application of dues. Then I come to Supreme Court in a contempt petition. After the matter is dealt with here, they issue me a no due certificate.
Show that the transfer charges were consciously addressed by this court in the order.
Yes. Lordship is
Not indirectly here, there.
They have raised this issue in the first round of litigation before in the contempt jurisdiction, first contempt jurisdiction. First, I will show that to your lordship. Lordship may see page 35. Page 35 of the my petition.
That is the reply.
That's the reply by them in the first contempt petition.
Yes.
Page 35. The para 3 of the EMP 2015 clearly stipulates that all
Which page? Which page?
page 35.
Yes. Which para?
Para 6.
Yes.
The para 3 of the EMP 2015 clearly stipulates that all service requests shall be dealt as per the provisions of EMP 2015, including charging of fee, processing fee wherever applicable. Furthermore, as regards pending application received before coming into force the EMP 2015, the same shall be considered to have been filed on 16/10/12. Next para, that as per the details.
No, therefore, it is applicable with retrospective effect.
Yes. Now, that as per the details of the shareholders submitted by the petitioner entity, out of the original 7 shareholders, 6 shareholders, namely Sushil Bagla, Srimati Pushpa Bagla, Arun Bagla, Beena Bagla, Rishi Kumar Bagla, and Sunita Bagla made an exit as shareholders from the petitioner's entity with effect from 8/7/1996. And the 7th shareholder made exit on 13th June 2011. Out of the 8 current shareholders, 4 shareholders, namely Ashok Kamal HUF, Nalini Kamal, Ashok Kamal, Avekshit Saras, entered into the petitioner entity on 12/12/86. The 87 is the allotment to me. Srimati Khushbu Saras entered into the petitioner entity on 13/8/2004. Orient Agro Private Limited entered into the company on 21/12/2011, and remaining 2 shareholders, namely petitioner entity, on 9/11/2019. Thus, the caption plot is deemed to be transferred by way of change in majority shareholding with effect from 13 June 2011 in terms of provisions of EMP 2015. As per the provisions of, as per the said provision, especially clause 8.3, 8.7, the petitioner was required to apply online for transfer of the plot by way of change in shareholding and is liable to pay the transfer fee for regularizing the transfer of caption plot by way of change of 100% shareholding the petitioner entity with effect from 13/6/2011. Shareholding as
Now show the order of this court,
Yes.
which dispensed with this payment
Yes.
for getting NOC and permission to build.
Yes. Now, page 55 is the 56 is the order.
So you are complaining of 3 orders. You show all the orders
Okay.
where this issue is addressed.
Because I have page 56.
56. That is the first order.
So that is the last order by this.
All right. 31/7/23. Sangwan, we will hear you.
Page 56. No due certificate has been handed over in the court. Insofar as prayer D is concerned, the respondent being at fault, the natural sequitur would be the period of construction would stand extended from the date of issuance of the certificate. Certificate is on the left side of your lordship paper book at page 55.
We are on computer, so it's up.
Sorry. Page 55. This is in reference to your request as request to the caption subject. In this regard, this is to inform you that as per the records provided by HSVP, that is Huda, all the dues towards plot cost has been received and nothing is due as on date towards the same. This
Plot cost.
that is the error what they did, because this was in reference to page number 25. Page 25.
No, you show that this has been dispensed with. Mr. Anubhav, you know the law.
Yes.
In a contempt jurisdiction, if it is a palpable violation, court will go into. But if it is involved reasoning, you will have to work out your remedy. We will allow you to work out your remedy, such other remedy as are available in law, because today you are now claiming refund of 72 lakhs.
Why I am doing so, my lords?
If you had paid the money under orders of this court, it's a different matter. You have paid independently. Now, this is, if they are entitled to the money, it's public money. They are a public authority. If you have wrongly been deprived of money, you are entitled to refund. It can't be gone into in contempt.
The order at page 56, which I just showed to your lordships, lords, was passed in pursuance to their own certificate, which is at page 25 and 26 of your lordships paper book, my lord.
So that.
Yes.
Now quickly, we have spent enough time.
Yes, page 25, 26.
Yes. This is at a point when they were not aware of the duties. All this will require adjudication, instrumentality of a state. If you think you have been wrongly deprived, you avail your remedy.
Liberty to approach the High Court for this.
Just take down. Allow them to go back.
May I just point
Yes, Mr. Sangwan, you wanted to say.
as if my lords have directed
No. We will couch it accordingly. Can we stop him from filing any number of writ petition? We can only dismiss it.
stop anybody from filing anything. We must earn our bread and butter for that. The original dispute was with regard to resumption of.
We wanted to be satisfied because repeatedly they have come for contempt. We wanted to be satisfied that you are not harassing them.
Situation, my officers will not dare, the fourth time, to come and file this.
You understand that?
Secondly, my lord, he has never raised this issue, my lord, in his entire pleadings with regard to transfer charges. The one-stroke clause was under the dispute, my lord, and the construction time.
But having raised it in page 35 of your counter, why did you not press? No. Why did you not press it here in this court before the order was passed?
Applied for taking the no dues, etc., my lord, and then he gave a shareholding. We came to know for the first time that the entire shareholding has been changed. It is not 70%, not 100%. The original my lord is nowhere.
No, but how do you
This issue was never neither before the High Court nor before this court.
Just take
He
it.
has himself said in his letter, kindly see his letter. He says that you kindly give me the no dues, you kindly allow me more time to construction. Both agreed to make this court. Now, Lord, this is a new issue. If at all he is agreed, his remedies are there, Lord. Why? How can he come again and again, Lord, in a decided manner?
This is a contempt petition.
just one order? The reason why your lordship said why was the reason I came again and again to this court is your lordship's order at page 6 of my short affidavit. Well, please see, my lords, your lordship that have in fact mentioned by concern, my lords, at page 6 of your lordship's order, my lords. This order is dated 15/12/2021. This is why I am running from pillar to post every time, my lords, to this court. Lordship, we have, my lords, we have little faith in the authorities for the reasons of the manner in which they have proceeded with making the petitioner run from pillar to post. It is obviously for some collateral purposes. Because this is the reason I every time I
No, this is vis-a-vis which order? Which order? Where is that order?
Produce is at page
56?
yes.
56 is the no due.
Yes.
Where is the order with which they are concerned that they are making you run from pillar to post?
Because they were not giving me a
Show that order. Show the first order.
yes. Order is at page
21, 2019.
24/11/2022. 24/11/2022.
No, what is 21, 2021?
Which order minutes?
Ganesh Metal, is it?
That's
Not-
a bulk matter.
The
Bulk matter.
lead
I was
matter.
the petitioner who considered before this.
This was the second matter, which was attached to that main matter.
Okay, now where is?
Now, his order is
Page 20. Page 20 is the first order passed by this honorable court.
23 precisely, my lord, is the main order, my lord, concerning this petition.
20, starts at 20. My civil appeal is
Yeah.
181 of 20.
Yes, yes, read that.
Yes. On leave granted, on hearing the learned counsel for the parties, what emerges is that was an earlier allotment.
No, you are reading the second order. You read your order.
That's my order.
A perusal of the impugned order.
Yes, this is my order.
Ah.
Page 20 is my order in my civil appeal. Civil appeal number 181 of 182 is my civil appeal.
That is actually here, page 20.
Yes, my lord, it is page 20 in my lord's. My lord, I am having the same copy which my lords have.
Page
Page
20.
20 is the order. my lord.
Yes,
Yes,
yes, read that.
On hearing the learned counsel for the parties, what emerges is that there was an earlier allotment of plot in question which was cancelled that went into litigation. The result was that possession could not be handed over to the appellant despite allotment letter being issued on 29/7/1980 till 1/9/87. It is also an accepted position that all payments have been made by the appellant and a no due certificate has been issued on 30th of July 87. The appellant sought registration of sale deed in his favor, but the same was not done, and the reason for the silence on that aspect on behalf of the respondent is not borne from the records. It is also an admitted position that construction was not made within the 2 years period of time as per the allotment letter, which would expire in 1989. But instead of extending the time period, ostensibly on account of the fact that appellant had planted some trees for manufacturing of raisins and installed tube well, which was stated to be in conformity with the land user, the allotment was cancelled on 17/9/1990 with a direction for resumption of the plot. Further proceedings filed by the appellant were also unsuccessful. In view of the submissions of learned counsel for the parties, we really do not find that the impugned orders can be sustained. It was a fit case which should have been examined on merits for extension of time, more so by the reasons of there being such a delay in the appellant itself enjoying the property on account of previous litigation. Unfortunately, 30 years have been lost only in this litigation. We thus set aside all the impugned orders, remit the matter back to the Chief Administrator Huda to have a fresh and realistic look into the matter, to felicitate the appellant to enjoy the property fully paid for the permissible user by granting a reasonable extension of time for about 2 years from the date of grant of permission on terms and conditions as may be specified by the Chief Administrator Huda.
All right. After this, what happened? You applied.
For the registry of the document, for the registration. They did not register the conveyance deed. We filed a miscellaneous application to this court. The miscellaneous application was allowed by the order dated, my lords.
4/1.
Yes, 4/1/2022 at page 23.
Yes.
My lords have it?
Yes.
Yes. The letter has been issued on 20th/12/2021, albeit at earlier address of the company, even though petitioner was communicated at the due address for considerable period of time. The said letter was not placed on record nor received by the petitioner, but learned counsel for the respondent has made it available to the learned counsel for the petitioner during the course of Passover. Learned counsel for the petitioner points out that getting sanction for plans and to construct within a period of 2 years as per the letter dated 2012/2021 would be meaningful only if conveyance deed is registered. Otherwise, the sanction of plan itself would be a problem.
All right. Then.
On our very learned counsel for the respondent states that the conveyance deed can be executed immediately. We thus issue the following directions. The petitioner will approach the managing director HSIDC within 3 days from today, and respondent will ensure that conveyance deed is executed and duly registered within a period of 15 days. The period of 2 years as per the letter dated 2012/2021 will commence from the date of registration of the conveyance deed. We hope and expect that respondents will not give any further cause to the petitioner to approach this.
Correct. When was conveyance deed executed?
Now, conveyance deed is executed, my lords, on 4/2/2022.
All right.
The plan is sanctioned on 27/7/2022. The registration of MSME is granted on 14/9/2022. Now, my lords, is the on-field certificate which is published on their website, which is at page 25. Annexure P3.
Dated?
This is dated 8th of November 2022.
This said no dues.
This says no dues even for plot cost 0, other dues 0, and enhanced cost default 0.
All right, then.
Now, there is a rule in their books which says you verify, physical verification of this online certificate is required. We approach them, they say no, we will not do it. They reject our application. That order is at page 24/11/2022, which is at page 24/11/2022, which is at page 9 of the additional documents.
22/11 must be. 9 is it?
24/11/2022.
All right.
Which is at page number 9.
All right. What does it say?
Yes, Your Lordship has minutes. Annexure A3 of the additional documents.
Hmm.
You not have it?
Yes.
Now, dear sir, this is in reference to your online request dated 22/11/2022 as regards the captioned subject. In this regard, your attention is attracted towards this office letter number such and such dated 19/1/2022, by which you were informed that as per the details of the shareholder provided by you, while your letter dated 16/1/2022 received on 17/1/2022, it has been observed that 100% of the original shareholding has been transferred with effect from 13/6/2011, which was not informed earlier to this office or to HSVP. The said 100% change in shareholding is required to be regularized as per the provisions of
All right.
EMP.
All right. All right. Then on this
Of the above, your request for no dues is rejected.
came again.
I am in contempt here. In the contempt, notice was issued. They appeared, they filed a reply.
That you showed me. They showed me at 36. That show the order which resulted in the.
Yes.
That also you showed us. That
Yes.
is the
Page 56, page 11, and except P11.
page 56 is the plot cost.
No, but the page 56 is the annexure P11 of order of your lordship, 31/7/2023. It's part of the short reply notes on my behalf.
NOC handed over.
Yes, and no due certificate has been handed over.
Is there NOC?
This is at page 55. Now here
All
they
right.
the plot cost.
I know. Then you tell us after this, where was the demand for this?
Now the demand came. Maloj, on 29/1/2025, and even Maloj.
Where is that? Just show that.
It's at page 9, Maloj, page 9 of the last second additional document, Maloj, on my.
Second additional document.
Yes.
Yes, I got it. When they gave you the NOC with the land plot cost alone, you should have objected saying.
That's what Miss Maloj, that is what.
And then.
But that is the problem, Maloj. We never thought that public authority will do this like this, Maloj. They will just pick and choose, Maloj, when the statement says it's 0, and even Maloj, see page 62.
Do you dispute the 100% change in shareholding?
Maloj, I am saying.
Your only point is it won't apply. The scheme won't apply to you
Yes.
because yours is 2011.
And my majority of shareholding was.
Now the question of
57.
prospectivity, retrospectivity for an allottee who in 2011
Yes.
has got his allotment, notwithstanding the cancellation in
87.
regularized by this court's order of 20th January 21, whether he should be covered, etc., is a question to be decided elsewhere.
We'll finish it off. Well,
Just take.
just one.
Yeah.
Just see page 62 also, Maloj. Your Lordship, page 62.
Hmm.
It's the account statement, allottee account statement. Till October 2024. That's their statement, Maloj.
That is. Anyway,
Credit balance.
you challenge this 29(1) and work out your remedies. Just take down. We have heard Mr. Anubhav Kumar, Learned Counsel for the contempt petitioner stroke appellant, as well as Mr. Sangwan, the Additional Advocate General, for the respondent. facts lie in a narrow compass. By an order of 20th January 21, this court, while setting aside the cancellation of the allotment purportedly made on the ground of non-compliance with the condition with regard to construction, remitted the matter back to the Chief Administrator, Haryana Urban Development Authority, back at HODA, to have a fresh and realistic look into the matter, to facilitate the appellant to enjoy the property for which amount has been fully paid for, and grant reasonable extension of time about 2 years from the date of grant of permission on such terms and conditions as the Chief Administrator may impose. Thereafter, there was an issue with regard to the refusal to execute a conveyance deed for which the petitioner again approached this court by filing miscellaneous application number 1790-1791 of 21 in Civil Appeal 181-182 of 21. And this court directed that the conveyance deed ought to be executed within a period of 15 days. Full stop. A further direction was given that the 2-year period for completion of construction will commence from the registration of the conveyance deed. It is undisputed that the conveyance deed was thereafter registered on 4/2/2022. Full stop. The plans were sanctioned on 27/7/2022. The petitioner submits that MSME registration was also obtained on 14/9/22. According to the petitioner, under the online certification dated 8/11/22, no dues were shown towards the land. However, the petitioner submits that
There are also no due zero.
according to the petitioner's contention, it was shown as
Other due zero.
dues with regard to, as regards the petitioner was concerned. I will not say which category. We will not say. However, since as per the rules, the online certification has to be verified with the documents, and when a request was made by an order of 24/11/2022, no due certificate was denied on the ground that since there has been 100% change of shareholding in
11.
name of the company,
Orient Raisins Limited.
Messrs. Orient Resins Limited, of which the petitioner is director, and since under the provisions of EMP, full form, Mr. Sangwan?
State Management Policy.
State Management Policy 2015, applicable fees and penalty has to be paid and since the same were not paid, the request for NOC was turned down. Undeterred, the petitioner approached this court again by filing
But 783 and 784 of 20.
that resulted in the order on 31/7, no? Undeterred filed a contempt petition number, civil number 783-784 of 2023. Full stop. A reply affidavit came to be filed by the respondent authorities
May 23.
12th May or 7th May? 12th May 23. And that is at page 55.
So P8.
And it's at P8. On 12th May 23, wherein in para 6 and 7, it was averred as under. No, 6 and 7 is what they say that dues are due.
8 also, because 8 also deals with the shareholding, because 6 is EMP 2015, 7 is the name of the shareholders, and 8 is 51% changing shareholding rights.
Then you said wherein it was averred that because of the change in shareholding and the non-payment of dues under the EMP 2015, earlier when you say estate management policy bracket here and after the EMP 2015, the authorities were justified in not granting the NOC. When the matter came up for hearing on 31/7/2023, a no due certificate was handed over and the same was recorded in the order. The no due certificate granted was in the following terms. Copy page 55. Annexure P10, just the body. This is in reference to your request as regards to the caption subject. In this regard, this is to inform you that as per records provided by HSC, all the dues towards plot cost has been received and nothing is due as on date towards the same. Thereafter, on 29/1/2025, HSIDC, Haryana State Industrial Development, Haryana State Industrial and Infrastructure Development Corporation, HSIIDC, I think.
I would like to also point out.
I'll just finish this, you tell me after that. I'll tell you. A demand was raised on the petitioner under the EMP 2015 for payment of transfer fee of rupees 72,27,461 and processing fee of rupees 10,000. Agreed by this demand, the petitioner is back in this court complaining of violation of the orders dated
Orders.
I know, 21/2021, 4/1/2022, and 31/7/2023. We are of the opinion. In the meantime, Mr. Anubhav Kumar, learned counsel for the petitioner, also submits that under protest, the payments have been made, and his endeavor in the present contempt petition is to seek refund of the said money by demonstrating that the demand is illegal. We are of the opinion that this issue as to whether the demand raised by the letter of the HSIIDC dated 29/1/2025 is justified or not cannot be adjudicated in the contempt petition. It is well settled that any matter which requires an involved consideration and where contempt is palpably not visible cannot be adjudicated under the contempt jurisdiction. Being a fresh cause of action, the contempt petitioner stroke appellant will have to work out his remedies by initiating such other appropriate proceeding as may be available to him in law, available to them in law. We grant the appellant the said liberty. Yes, now tell me.
Pointing out that the allotment of this plot was by Haryana Urban Development Authority. Subsequently, not all the industrial estates were merged in HSIITC, and this is how we have inherited the present alleged
HSITC, where we say, na, bracket, the successor in interest of Huda. That's all, one line.
just to avoid the confusion that how both of them are coming.
We are not saying retrospective, prospective, etc. I don't want to harm your case. The contempt petitions are disposed of in the above terms.
Whether of Huda or because now they have come up with a.
All contentions between parties are left open.
Yes.
But with respect, my lord, in the entire 3 rounds of litigation, never ever, my lord, this issue was touched with regard to the transfer because he never submitted his shareholding to us.
Anyway.
When we came to know in 2022, we raised this issue and we said that right now we are complying with the order. This we will deal separately. He sent us a reply saying that yes, it's all right. Allow my conveyance, give me my building plans, etc. I will go ahead.
That's over.
That is also part of the record, Lord. Page 22 and 23 of my reply.
It's over now. It's over. It's over.
Thank you, Lord. I'm obliged.
Thank you.
Please note, in item 5, peculiarly what happens is in a suit for possession, the plaintiff fails to avert when he was dispossessed, when defendant took possession. An application is preferred under 711 A and B. The High Court only looks at D for the contents to take out. That is settled law. If it's not in the plate, you can't look at rest of the articles. So he takes this, the single dismisses the application. But the single judge also records the issue that there is no further action.
Yes.
In the also clause that the issue of no further action has been raised by the defendant. But there is no finding on this issue. The same error in law is carried out by the in the FAOS by the division bench of the High Court. And now we are before your lordships. May I just show to my lords the prayer in the suit and the pleadings in the suit, how he is the owner and how he is distributed.
Quickly, 5 minutes, because this is a 711.
Yes.
You have concurrently lost. We are nipping a suit in the bud. You know the parameters of law. You may have other remedies out of one rule 10, whatever, Parivanandam principle. But if you want 711, you have to come within A, B, C, D. D is a palpable bar. Securitization Act. This bar. Now, this kind of bar which you are saying about res judicata, you relying on one judgment, they relying on another judgment, matter for trial. Now, show in that context cause of action, absence of cause of action.
Please have the amended claim, paragraph number 5, running page number 58.
Yes.
the defendant is in unauthorized possession of a portion of the plaintiff's property number such and such.
Yes.
Now please have paragraph number 6.
Yes.
Defendant is an illegal or unauthorized occupation of the suit property. Now please lastly have para 7 now.
Yes.
The second last sentence. However, keeping in view the law of limitation in view, the plaintiff restricts his demand for damages to 3 years preceding the date of filing the suit. So admittedly, I have been in possession at least 3 years before, as per his own case. Now, my lords, please see.
That's on mean profits.
Yes.
Mean profits.
At least I am in possession for 3 years.
Otherwise, the suit is for
Possession.
possession.
Please have paragraph-
Based on title.
Yes.
That is, his claim is based on title.
Yes. I'm so grateful because that finding will relate directly to Article 65 of the
65 of the Limitation Act.
of this.
Yes.
So please now have paragraph number 11.
Yes.
On 11/5/16, when the office bearers of the plaintiff requested the defendant to vacate the property and return its possession to the plaintiff, defendant openly declined. That's it. Plaintiff states he is owner in possession, that he is an owner based on title, does not disclose when he was dispossessed, does not disclose when the defendant got into possession.
That is for you to come and say all that.
Absolutely. Now,
Your defense is based on?
my defense is that I was a tenant of the predecessor in title, Mr. Gokul Chand. Gokul Chand's tenant. After that, Gokul Chand gave a gift deed, and this plaintiff, just for the merits for 1 second, plaintiff challenged that in a
Gift deed to whom?
to Harpriya.
The tenant.
Yes, that
Landlord gifted the property to tenant.
yes, that is my defense. That issue.
I wish if that happens in all cases, straight away rent control matters can be disposed of. All good. Anyway, people have different mindsets.
That issue is challenged in a suit in 1960, and plaintiff is found to have no merit in his plaint, and suit decreed against plaintiff. I am not on that 7D issue, but this is what the facts are. Now, my lords, please see para 13 how he explains his cause of action.
Para 13.
Yes. The cause of action arose when the suit property was illegally occupied by the defendant, fails to place a date. It further arose on 1/5/16 when he asked for the property back and refused. Now please have the prayers on the following page.
Nobody is using Arivanandam these days. Krishna says,
Absolutely.
order 1, roof 10,
Perfectly on this point.
put on the box, put in the box. But then there is a procedure. Court has the power to put the plaintiff in the box. And you should have excised it in the single judge. Now you are showing Arivanandam here.
My lord, please, your lordship receive the prayer.
Hmm.
It is a suit for possession.
Hmm.
Please let me read for your lordship's consideration again. Article 65 of the Limitation Act. Description of the suit. For a possession of immovable property or interest therein based on title.
Title.
Period of limitation, 12 years, sufficient time. When does the right to sue accrue to you? When the possession of the defendant becomes adverse to the plaintiff.
Correct.
So it is for you, Mr. Plaintiff, to plead when I came into possession, or alternatively state when my possession became.
You read 64, Article 64. Now
Yes.
you're on 65, you will know the distinction between
Yes.
64. You read 60.
64 is for possession of immovable property based on previous possession and
Correct.
not on title.
Correct.
So his case is based on title.
Title. Once it is based on title, usually, adverse possession is set up. In some case, in your case, it's based on another title.
Right.
So the law is, it commences on the day he sets up an adverse title. Adverse title. So 65 will apply only 12 years from the day it becomes adverse, not 12 years of possession. That is the distinction between 64 and 60. So you are, all this will have to be thrashed out in the suit. You have to file a written statement, show your case. Who is in possession now?
I'm in possession.
He-
I'm in possession. But your lordship may just appreciate
File what?
He does not state how I came into possession, when I came into possession. He simply states that when I asked you for possession back, Then you refused, but he doesn't even plead that his ownership is at worst mine.
When we are nipping in the bud, we are only on the meaningful reading of the, I mean, unless you show it is artful drafting or except to the exception.
See,
Not these kind of matters.
Rule 1 E.
Order 7.
Rule 1.
Plain running into nearly 49 pages.
It's 15 paragraphs of the plaint. Plaint is 15 paragraphs. Just I want to show Order 7, Rule 1E.
Yes.
There are mandates for what a plaint must contain. As your lordship, there are mandates for what a plaint must hold, as what your lordships have continuously held. That the plaint shall contain the following particulars. And then, my lords, may please have E. The facts constituting the cause of action and when it arose.
It's a bundle of facts.
A bundle of facts. But the premises of his first bundle of facts on which his statute must stand is the fact how he or the defendant came into possession. Simply saying, I walked into Mr. Chopra's house, Mr. Chopra said he will not return the property to me, does not give me a right to sue. Because the right to sue has to not just occur, it has to approve.
He has to have said that his title derived this way, that way. Having heard Mr. Shiv Chopra, learned counsel for the petition. Better nothing. We find no grounds to interfere with the special leave petition. Special leave petition is dismissed.
Grateful.
You placed the case very well. Lekhan.
Please, your lordship.
Yes.
Lordship, on last date.
That Rajbir.
Yeah, the LRs of respondent number 5 and respondent number 3. They died after the judgment of the Honorable High Court, your lordship. They filed the SLP.
What is their grievance?
Against the impugn order, your lordship, they filed the SLP order. And the SLP was dismissed, your lordship.
I see. Common interest with you? Your common interest, same. Where is the order?
Your lordship, this is the memo parties of the previous SLP, your lordship.
Yes, Rajbir. And they are son of late Gurdiar.
Yeah. This is respondent number 5.
You are Mam Kaur.
Yes.
And how is the relationship?
Mampur is totally different, your lordship. They are the LRs of Ram Sarup, your lordship.
So you have a family tree. Will this dismissal affect you?
Yes, your lordship.
It will affect you.
Yes.
Identically situated.
Identical situated, your lordship.
Anyway, you placed the case since appellate court was in your favor.
My favor, your lordship.
You want to say something, you say. 2 minutes. Question of law, forget it's Punjab.
Yes, yes.
That is not required.
This will be constitutional bench.
Pankajakshi, I argued it. I checked up it is followed also in another judgment recently. Because that Kulwant Kaur had come in the middle and created a confusion. So when Kulwant Kaur was cited, Justice Nariman said we'll go into that question.
Yes, yes, your lordship.
Now you tell me now what is the point in your favor?
Your lordship, the Honorable High Court has failed to consider the local commission report, your lordship, only your lordship. That is all.
But all that was considered by the trial court.
Not trial court, your
No.
first appellate court, your lordship.
First appellate court considered. First appellate court committed an error on all the 3 aspects. You come to Justice Kshetrapal's judgment. Correct. Only, as my brother says, only ground is cattle was, tethered and grazed there. If you see the finding, page 7, para 13.
Absolutely. Similarly, the first appellate court is recording that the local commission
Has not been tendered in evidence. It was tendered in evidence. Local commissioner nominated as an officer, something submits so and so,
that is only all. That is
having heard and concept of the petition. If I know merit in the special petition dismissed. Thank you. Lay control.
Your Lordship, I'm being led by learned Deputy AG.
Nothing, Mr. Vivek Jain, you argue this. You want to harass the employee like this?
Lordship, may kindly
Drop the charge sheet. You drop the charge sheet and you say you won't pay him interest. You saw the matter. Then what do you say?
Your Lordship, the charges were dropped later on.
You can initiate drop whenever and not pay, delay his deterrable benefit and not pay interest. Where is Mr. Vivek Jain?
His legs, Your Lordship. In another court.
So get him.
Bless Your Lordship.
Get him, we'll impose some costs when he comes.
Your Lordship,
Yes.
and for the petitioner.
Yes.
Your Lordship, this petition is basically challenging the violation of fundamental.
Use the mic.
This petition is basically challenging the violation of fundamental right
Hmm.
in 106th Amendment of the Constitution, in which 33% reservation has been given in Lok Sabha.
Any
But-
connected matter is pending.
Your Lordship, Jaya Thakur versus Union of India direction has been given in the previous hearing, and I filed an IA application relating to the comparison of the two cases, that how this case is distinct from the other.
Already.
And I filed an IA application to Pro. Your Lordship's, Your Lordship, the Jaya Thakur case that has been pending and that has been compared with our matter, a comparative table has been presented in the IA application that proves it is distinct from the previous one.
No, what my brother points out, page 44, you are Miss Shruti Bisht. Are you yourself in person? In person. Okay, next time if you are in person, don't wear your band. Don't remove it now, you just argue as it is. You come to page 44. Come to your representation. Now you file it on when 30th November? 6 January. Yeah, 6 January. When did you file the writ?
Should we file the writ in February? We give time for.
23rd January.
Mr. Nataraj, you are approving?
Yes. I don't think
not even 2 weeks.
Not even to. Are there any other matters pending on this?
I think that Jaya Thakur is disposed of as of now. Because the already amendment has been carried out. Here he wants the amendment to provide some reservation in Rajya Sabha. That I don't think can be enforced through court proceedings.
Lordships kindly give an
Please see
opportunity
the
to
prayer.
compare the two matters.
You sure? Okay. She wants to show the comparison. We'll just hear her also.
Very
That in Jaya Thakur case,
Page.
Your Lordship, the IA application that is on the record, page number 3.
No, first you show your prayer, then we will go there. Show your prayer.
Prayer is in the nature of mandamus to give directions to the respondent to take action towards implementing 33% reservation in Parliament for women in Rajya Sabha. And because it's an equal status to Lok Sabha and Rajya Sabha, that is why the ground of action was the distinction is being made. If Lok Sabha mein there is 33% reservation, then why Rajya Sabha has been kept away? And Your Lordship, by the directions of Honorable Chief Justice, the comparison of Jaya Thakur versus Union of India has been given, and the IA application that has
No, you know how Lok Sabha is elected direct election.
Yeah, your lordship,
How is Rajya Sabha election?
that is what makes your lordships in
No, indirect election. It will depend on the legislatures, etc.
in the petition, your lordships, there has been certain practical grounds on which I am contesting this matter, that there are several, practical differences that a woman has always been facing. And that is the reason Article 15 Clause 3 has given reservations and provisions for women. Because the political structure, the way it goes by protests, dharnas, and so much of, no electoral
No,
reforms.
you show the chart. Where is the chart?
Part of the comparison between the case. The I application, your lordships.
IA.
See the page number 3 of it.
Where is Jaya Thakur order? First.
Jaya Thakur order, we have filed a comparative chart, your lordship, to compare that the two cases, because the paper books.
Jaya Thakur order. Is the Jaya Thakur order here?
It was supposed to be presented in the court, and the direction was given. So I have drafted a comparative chart of the two.
No, we need to see the order, then we will see the chart. What is the order, Mr. Natarajan, Jaya Thakur?
Yes, that has been disposed of without this one. That can be done through court. That's what they court said by 10/1/25.
Same prayer?
No, they wanted reservation everywhere. Insofar as the Parliament is concerned, it's already provided. So nothing survives there.
Your
Here they
lordship-
want in Rajya Sabha as well. That
Your
cannot be
lordship-
enforced through court. It's a Parliament, Lok
You
Sabha
have to
amendment.
produce,
The
you
amendment
produce
is-
that order.
Yes.
It says at the end that a legislative, it cannot be amended unless there is a contravention of fundamental right.
No, where is Jaya Thakur order?
Your lordship then kindly allow us to bring that order in the.
Learned Council prays for and is granted a week's time to produce the order in, what is the number?
WP 1181 of 23.
WP 1181 of 2023.
Yes.
Dr. Jaya Thakur versus Union of India.
Yes.
Yes.
Dated 10/1/25.
The order dated 10/1/2025.
Yes.
Call the matter after 2 weeks. Yes.
Kindly pass over the matter. The arguing counsel is in court number 1.
Court number 1. All right. Pass over.
Much obliged.
Yes, Mrs.
A large number of matters are pending in various high courts.
We are on caveat for the LIC. We are led by the learned Solicitor General. I'm only seeking for a passover.
Pass over.
Agenda futile, that will be.
There be has.
See, we will see whether notice has not been issued yet. So we'll see. It's a validity matter. Yesterday also same thing came up by the termination that have taken place under the very rule. No? Your own matter, Ms. Asmi. Challenge the validity. Here is a challenge to the validity. So let solicitor come. We'll have a look at it.
There are about 50, 60 cases pending all over the country.
No.
Let solicitor be there.
30%.
If you are not here and somebody would have asked, I would have given. In larger private interest.
May I request for a passover? Mr. Gaurav Agarwal is briefed in this matter. Item 11.
All right. This is municipal corporation. Yeah. Ask him to come whenever he's.
Yes, unfortunately, the learned registrar misses the things and says that this second contempt petition is not maintainable. And
Mr. Ashutosh, you come to the registrar's order. There's such a detailed, cogent order.
registrar, without hearing, without any hearing to me, has passed this order.
It's a lodgement order.
The first contempt petition was against the where my futile this visitation was there. Lordship. Whenever I used to visit, they used to say that either children has gone for the.
You come to page 20 in the diary number 8335 and read slowly the order. You give background.
There was a POSCO case which was filed against me. Somehow this matter got set up.
Use the mic.
There was a POSCO case which was initially filed against me. Thereafter, matter travelled before this honourable court. Before this honourable court, the matter was settled. As a father, I left over my property in defence colony for the children and other thing. I was given a visitation right, specifically cautiously given by the honourable court. I wanted overnight visitation right. Honourable court said initially we give you 2 days in a month. Thereafter, over the period after 1 year, we'll see whether let us start the thing, and over the period we'll decide your visitation right for the weekend and for 15 days and other thing also for this what you call vacations and other thing. That was the order which was passed on 28 November 2022. Now, Initially, for first 4 visitation, the children met. The children were allowed to meet me in the 2 months. I had a very good bonding with them because my child, who was from 11 months old, I have been taking care of them. My wife traveled all the way to Singapore for her work, but it was me who was taking care of them. So they had a very good bonding with me. I continued. Now, what happens when the mother travels back to Singapore? It was order passed in November 22. From February 23 onwards, the issue starts. Whenever I used to go visit for children to visit, it was said either they had gone for a tuition or for some other things like that. Every time the excuse was made. That was the first contempt petition which I came before this honorable court. This honorable court in August 23 says that no, we're not interfering in this contempt part of it. We do one thing, you give you liberty, you take your remedies. That was one part of it. Now what happens?
Now here, pausing here, the 28/11/22 order. First of all, closed all the cases between you.
Yes.
Then it granted divorce.
But that order is 26.
It is part of the impugned order. It is extracted. Then
part is not my visitation rights. Another thing is not extracted over. That is what I'm saying, Lordships.
Where is that order?
At page 26.
All right. Whichever part you want, you place.
At 28 para 8.
28 para 8. Yes.
The parties have entered into settlement dated 19 November 22, and the terms as agreed between parties are taken on record and shall be considered part of this order. In terms of the settlement dated 19 November 22, it has been jointly consented and agreed by the parties that both the children, Diya, the daughter, and son, shall remain in exclusive custody of their mother, Payal Maheshwari. Father Devendra Nair shall have the visitation rights. The condition is agreed in terms of settlement for visitation rights is important, Lordship. Both the children are in exclusive custody of the mother, Payal Maheshwari. Devendra Nair, being the father, will have visitation right to begin with, at least for a period of December 2023, up to December 2023. Both the children named Diya and Dhruv are permitted to meet their father, Devendra Nair, on second Saturday and following Sunday of every month from 10 a.m. to 4 p.m. With a further understanding that the father, Devendra Nair, will take the responsibility to pick up and hand over the custody of the both children back to their mother, Payal Maheshwari, on or before by Gurugir at such and such address. That the term of visitation will be modified for the children after December 23 as per the education law. So based on this, I was granted the visitation right. I was visiting the children. That's what I submitted all of the details I have at page, the entire chart of the visitations which are there, Lordships. That is at page 178. I extracted that chart. Page 178, Your Lordships. That is an actual P8.
No, thereafter what happened?
Thereafter, I started my visitation initially for two months. That is from November, December, and January. Everything was fine. Children used to meet me. They were very happy, and we had a very good bonding with each other. From February 23 onwards, issue starts. Whenever I used to go and meet the children, I was given an excuse that children has gone for tuition or some other extracurricular classes or other things. Every day on the very particular day of my visitation of Saturday and Sunday. I made a suggestion. This can be, if the children are on the tuition or such, that can be adjusted because you are aware, the court order is there. That can be adjusted to other 3 days of the month, other 3 weekends of the month. That was not done. Now, against that, I came before this honorable court. This honorable court, by virtue of that order, that the first contempt petition, may just see, Your Lordship, what is the ground which is in the first contempt petition. It is at page 57. Section A4, page 57. At 67. At 67 paragraph. I'm not taking the other part of it. I'm straight away limiting to that what is specifically period there, Lordship. That though the mother is not staying with it because she was staying now in Singapore. Though the mother is not staying with the children, still she is not allowing the visitation of the petitioner to happen and is forward with her sister and parents and ensure the children are not able to bond or meet with their father. This has been scenario since February 23 till date. The contemners are well aware of the visitation date which has been fixed by order date 28 to be second Saturday and following Sunday of each month. It is submitted knowing very well that custodial parent will have an excuse ready for the visitation under the care of tuition or of the children. It is submitted once it has been decided that second Saturday and Sunday will be for the visitation from 10 a.m. to 4 a.m. Let us continue or to have the date time for the tuition. It is not the case that for a particular day which would be in a conflict or with adjusted any other day of the month. This further summon contempt intentionally make the prefix visitation defutile and do not even adjust to the alternate.
All right, what happened to this contempt petition?
Petition was disposed of by this Honorable Court at page 97 on 25th August 2023, saying that we at 93. The petitioner shall be at liberty to take such other step as may be permissible under the law for redressal of the grievances, saying that you can seek for execution or something like that because day-to-day monitoring is not possible for us. You can go before the executing or between monitoring. Now what happens during the pendency of this? When I go to meet children in July, this is continuing in July 20, what happens? I go to meet children. Children will grandparent doesn't say anything. And when I continuously ask them where are children, I have to keep because there's a day which is picked by the uncle. They were not giving any responses. That's the sister-in-law of my, that is the sister of the mother.
When did you last see the children?
July 2024. Before that, it was in June 2023 that I was in July. What happened when I called the police saying that this is not been done? Then they informed the children are taken abroad without any order of this Honorable Court, without any modification of order of this Honorable Court. The children are taken abroad and it is said they will not be returned. That's what the second contempt petition specifically my ground. Just have a look at that.
That is in the present contempt you are saying.
At page 99, the contempt petition starts at 109. Page 99, the present contempt petition, at 109, page 109, paragraph number.
Page 109.
Yes. I'm taking back to the paragraph first, which I'm taking other. That on third, Lord Schneider, paragraph.
Yes.
That on 13th July 2024, when the petitioner had gone to visit his children, he was appalled to know that the children were not there at home. Initially, the respondent container, particularly container number 3 and 4, were not ready to inform the petitioner where the children were. The respondent container were making one excuse after another. Finally, the container number 4 told the petitioner that the children had been taken abroad permanently by the container number 1 for the education. The petitioner was shell-shocked and traumatized and believed that he will be completely deprived of the complete love and affection of his children. As the petitioner got no further response from the petitioner container number 3 and 4, they have to make a PCR complaint. The container number 3 showed WhatsApp message on container number 1 that the children are no longer in India. The petitioner was informed the children will not return to India in future. The petitioner subsequently made a complaint of such and such, which is beneath. Thereafter, para 30. That is my ground eruption. That as this Honorable Court by order 28 to 22nd November 2022, the petition lawful custodian guardian of the children on second and following Saturday of every month. It is submitted there was no modification of the order dated 22nd November 2023 date. And as per the petition, only maintaining children's scheduled days. The respondent intentionally, with the malafide intent to frustrate the meetings and going beyond of the petition children, especially the son, the respondent number 1 and the other respondent had taken children beyond the reach of the petition, and also the papers will be this Honorable Court, which is based on.
This is the petition which is lodged now.
Yes, this is the petition. Now, before the registrar report, almost from July to December, I have myself also gone.
All right, take them. Please take them. This is an appeal. And Order 5, Rule 3. Order 5, Rule 3 of the Supreme Court rules. Which year is the rule? 1966?
2013.
2013. Challenging the order of the registrar dated 19/12/2024. Lodging the contempt petition filed by the applicant, who was a petitioner in the, who was the petitioner in the original matter, correct?
I was a respondent in the original matter. Was the SLT, I was the respondent.
Who was the respondent in the original matter?
Sorry, talking about the original matter is contempt, then I was a petitioner in contempt.
No, in the criminal appeal, criminal
appeal, I was the respondent.
respondent. Mr. Ashutosh Dubey, learned counsel for the contempt petitioner, stroke appellant, in this appeal, draws the attention of the court to the order dated 28/11/2022, wherein this court
8/28.
at para 8 recorded the settlement clauses, including the settlement clause with regard to visitation rights agreed upon between the parties. Under the said clause, both the children of the couple will remain in the exclusive custody of the mother, while the father was given visitation rights. According to the clause with regard to visitation rights, up to December 23, the father, who is the petitioner herein, the petitioner stroke appellant herein, will have visitation rights on second Saturday and following Sunday of every month from 10 a.m. to 4 p.m. Thereafter, the terms of visitation would be modified, were to be modified after December 23 as per the education program abroad of the children. Already it was noticed that they were proposed to go abroad.
Noted by the Honorable Court, yes, you will come back to us then according, because I said I wanted overnight visitation.
All right. Now, does this order record anywhere that it will be treated as undertaking between parties? See, wherever settlement is recorded.
And both the parties are willing to abide by the terms and conditions set out in settlement dated such as which have been arrived by them without any coercion and undertake not to raise any dispute whatsoever henceforth arising out of the matrimonial relation.
Mr. Dubey, Mr. Ashutosh Dubey also draws attention to para 10 of the said order, wherein undertaking of the parties not to raise any dispute whatsoever henceforth was also recorded. Mr. Ashutosh Dubey fairly brings to the notice of this court that an earlier contempt petition filed namely contempt petition civil 1109 of 23 was dismissed leaving the contempt petitioner liberty to take such other steps as will be permissible under the law for redressal of his grievance.
That order, page 97, Lordships.
I've seen that. That is where I got it. According to Mr. Ashutosh Dubey, the petitioners stroke appellant herein in this appeal was constrained to file contempt petition criminal diary number 148840 of 2024 on, when did you file this?
I just give it to you.
2024.
No, it was on 18th October. 18th October.
24. 18th October 24. For the reason that set out in para 12 of his contempt petition, and 13, which are extracted here and below. Copy from page 109 and 110. Mr. Ashutosh Dubey submits that a fresh cause of action has arisen for filing the contempt since, as per the order of 22/11/2022, post December 2023, for the period post December 23, appropriate modification of the visitation rights clause stroke order was to be obtained if there was any proposal for the children to study abroad. The Dubey submits that without seeking any modification, today he is told that the children have gone abroad and will never return to India. The Dubey also submits that the father has not seen the children since June 2024. And submits that the least he is entitled to is to have visitation rights with his children. According to Mr. Dubey, in view of the above fact, the order of lodgement passed by the registrar dated 19/12/2024 calls for interference. Issue notice to the respondent returnable in 4 weeks.
My lords, with permission of my lords, may I
Date in
speak?
July.
With permission of my lords, may I submit something?
Petitioner, there is the person can confirm the date of last visited is.
When did you last see the children?
My lords, it was in June 2024.
He has correctly pointed out that. Just 1 minute. You do one thing. Issue notice returnable in 3 weeks.
My lords, may I make one submission with?
Just 1 minute. Just 1 minute. List the matter on. There is a calendar here. There is no calendar here. May 2 p.m.
May I request one thing, that lodgement order has to be recorded because there's an intercept between me and the registrar and before this honorable court. Lordship may issue notice in the contempt petition because lodgement order has nothing to do with this respondent. The lodgement order as such, as per respect to submission.
See, like in a criminal matter, though at the initial stage you don't have to hear the party. When there is a revision, 401(2) says you must be a party. What I can do is issue notice both in the appeal against the lodgement order and in the contempt petition. Returnable in 3 weeks, list the matter on 20th May 2025 at 2 p.m. Yes, quickly, 1 minute.
My lords, I just want to submit that I am an unfortunate father who has been running from pillar to post just to give fatherly love, affection, and guidance to my children. And my lords, my daughter has now, I understand, gone to the UK, and my son has been taken to Singapore and been permanently deprived of fatherly love, touch, and affection, which is essential in the formative years. My son is today in class 8, my lords. He was just 11 months old when I brought him up single-handedly as a single parent here in Delhi, keeping aside my career, my health, everything in my life. Now, it would be utterly inhuman to insulate my son, who was so close to me, from parental touch and from sharing moments of joy and learning in these formative years. This is very essential for his healthy growth and his personality. My lords, my only submission is that I may be allowed to meet my children at least as per the earlier visitation order, which can be considered by my lords.
That is why, Mr. Nahar, we have listed it on 20th May before the closure for the partial working days. We have listed it before. Secondly, Mr. Dubey has placed everything urgently.
My lords.
We will see if we can at least ensure a video appearance till such time they are there. Or let us see what they have to say. We have to hear two sides to the...
Right, my lords. But the video appearance, the only hindrance is, my lord, earlier I had been granted video appearance by the Honorable Family Court.
Either you have to go abroad or they have to come here. If till such time they don't come without video, what can you do? At least these days video is there.
My lords.
Till a few years back, we had no idea how our relatives looked. Plus they came. All right.
Highly obliged, my lords.
Let's see what we can be done. There seems to be fresh cause of action, but they may have their own story. Let them come. Let's see, that modification point is a good point. Just correct the order. Just show me the order.
Highly obliged, my lords.
For the time being, the physical presence of the contemptor is dispensed to. Correct. Good. We don't have to call it. We don't want to treat it as contempt. Let us see if it can be treated as an IA and sorted out. You have to take instruction, Mr. Banerjee.
They can take actors. For the commission, it is we who had given this OMRs which were actually received from CBI. Now the panel has gone. Lordship had directed to be destroyed. We can't keep this.
We are stuck with 19 covers and we don't know what to do with it. No, is the proceeding in the High Court which was remanded over?
Panel got scrapped completely.
That matter, when Chief Justice came back and...
26,000, entire thing has gone. So what is the point of now? That's in between last day and today. That judgment has come.
No, I think suppose somebody wants to file a review, etc., let it be there.
We have the hard disk. This is a printout of...
No, we will say that let the records be kept as part of the other file. So that if the court suddenly wants to see, we don't know. What?
In fact, they are, my understanding, they are filing RPI.
Keep it as part of the other file for some more time. We will record all this and we will say that it will be part of that file.
It's for the state, we'll give the details.
Yeah.
For it.
It's common ground, Mr. Chen.
I was for the teachers.
See, this came at the High Court stage first round. Matter went back. Covers got stuck here. Matter is over. Second round, Supreme Court is also over last month. Chief Justice is the judge. Chief Justice spoke for the court. Okay, since it is only 3rd of April, you know, no, we don't want to say anything. We are stuck with this cover, 19 covers now. We are least interested in it.
That's why we said it can be destroyed.
Destroyed, is it? No. Destroying will be an extreme measure. And that will have its own consequences. by an order of 24/3/2025, Mr. Banerjee, Vikramjit Banerjee, the learned additional Solicitor General, informed the court that he would take proper instructions with regard to the 19 sealed envelopes which are lying with this court as part of the record in SLP Civil 16111 of 2023. Today, at the hearing, parties are ad item in submitting that after the order of remand made by this court, by order dated
9th of November 23.
9th of November, I was also part of the 9th of November 23 in SLP Civil 16111 of 23. The High Court disposed of the writ petitions on
22nd April.
what was it, writ petition or writ appeal?
Writ petitions. Was not by DE.
Writ petitions, I think this is Basak's statement. 24/11.
22nd April 24.
Division bench, the High Court disposed of the writ petitions on 22nd April 2024, and that against the said judgment, special leave petitions were filed, which have also been disposed of by judgment dated 3rd of April. After converting the same special leave petition into civil appeals, namely civil appeal 4800 of 2025.
There were some 150 matters.
Parties submit jointly that these 19 sealed envelopes may be directed to be kept as part of the record in civil appeal 4800 of 2025, since the sealed envelope contain OMR sheets
Which were seized, which were originally, we have taken printouts of copies of OMR sheets from the hard disk provided by CBI to us.
which contain copies of the OMR sheets taken from the hard disk and submitted to the court by Bengal, State of Bengal,
Commission.
by full name you give.
West Bengal Central School Service.
West Bengal Central School Commission.
School Service Commission.
With this observation, the matter is treated as closed as far as SLP Civil 16111 of 2023 is concerned. So that it's at least kept somewhere in sequence.
People registry can keep it in a digitized form also if they feel like.
Right now it's in sealed cover. What is to do? It's like holding a tiger tail now. What do we do with this?
No, they just played with the rules.
Let it be there.
I may be permitted to file the physical appearance.
Why are you not resorting to online, Mr. Sil?
This was a suo motu proceeding, so my name, the name has.
All right.
Please, as I said, conviction under POXO Act, the victim and the complainant, the victim and the accused both are juveniles.
No, you really argue the matter now. We have seen the evidence.
That's the evidence. The High Court has not seen had not properly evaluated the evidence. There's a
No, you place the evidence of the boys are on record.
Yes, I placed.
So
what is very important is how the complaint comes into picture. It's the PW1, Kumchand, who is the uncle of the victim. He files a complaint saying that on 18th when he came back, will have my additional document. I placed it on record.
Yes.
Page number 5 of my additional document, P5. PW1. Well, he says on 18th of April at around 2 p.m. in the afternoon, so and so, I was in the shop situated in Kalia, Kaila Devi. At around 9 p.m. in the night, I returned from home Kaila Devi. I was informed by my wife Lakhanti that Ramdeep, son of Surendra, who is aged about 5 years, was sitting in the cot lying under the neem tree. When our neighbor Dirigation Ashish came in with the ill intent and took away the nephew, Surendra Tinshet, which is situated on the other side of the house. Both of them laid the house and took away the underwear. But on hearing the screams and cries of the minor, my wife Lakhanti reached there, and soon my wife reached under the tin shed Both the minor pushed away my wife and fled away from the minors were in dirty, and the minor was in dirty condition. Therefore, wife came. This is while he's saying that he came in on the date of the event, the date of the incident.
You're on 8 days delay.
Yes,
All that.
Not only it is a delay. 18, he says in the evening he comes and the wife tells him that this incident has taken place. Now, so the wife, P6, which is page number 10, herself says she herself came to know about the incident 3 days after the incident. So, how
show that? Show wherever you want to show.
Page number 10. This is the wife.
It was a 3-year sentence, is it, in the Borstal school, in the correctional home. Now, thereafter must have been, what happened to them?
They are still inside.
They have been shifted to jail, I saw somewhere.
But they've completed 2 years of their punishment. They're still to undergo 1 year.
In majority also.
Yeah, but one of them has a 10 majority.
That's why they shift to the jail, is it? All right.
Well, may I have P6, page number 10.
Yes.
It's Bakhanti, the wife who apparently witnessed it.
Yes.
Incident pertaining to summer season. When I had gone to the hospital, my younger sister-in-law, Rajkumari, had gone to her parental house. There was no one in the house. Arushi and Sachin had gone, so I had gone for checkup of Pavitra to the hospital. I returned back at home at around 2:30 p.m. in the afternoon and found Suren lying in the house. And Ashish and Dilkesh from the teen shed pushed me and fled away from there. Suren was wearing only underwear and the underwear was having white stains on it. I inquired about
2022, they are recording. Should they not have anonymity on the names?
I agree, Manoj, but the entire trial court records their name clearly. I want.
Anonymity should also be of the relatives and witnesses, because you can easily locate who the person is.
It should be.
All right. At least you don't read the name when you're reading out.
I inquired the child and he told that he got hurt while working so-and-so and did not disclose anything else. 3 days after the incident, a quarrel over a masmalan took place between so-and-so and so-and-so, and at that time my son so-and-so disclosed before me that incident of wrong act that it took place with so-and-so, There was blood during gathering by so-and-so. The victim's mother returned back home after the pregnancy. But she herself is coming to know after 3 days of the incident. The uncle says on the very same date of the incident, he
actually traumatized.
If the mother was not in the house,
as far as witnesses are concerned, they are consistent, and it very often happens that the child is traumatized. And there is another case where we are doing. He did not even report to the parent. In the school, the counselor came to know. So we are not going to be impressed with this delay.
When the mother came to know about the incident 3 days after the incident, what was the point of lying on the first hand by
the threat is continuing. The spell of the threat is continuing. See, they are not out of the spell. It takes that spell to go. It takes a while for the spell to go.
I agree, but what about parents? Parents per se file a complaint by the cause statement.
Humiliation, threat, trauma, humiliation, as my brother points out. So, particularly, this is which village?
This is Karoli village in Mysore.
You see, imagine to go and complain. It must be a huge affair there. Because our society, we are concerned with what A will think, X will think, Y will think.
Even other the statements, the witnesses, here are here.
We don't think, we just think what others will think.
The statements here, the witnesses here are hearsay witnesses. Nobody has witnessed the incident. But what is being lied upon is that
exploitation of a boy for the sexual, and they will not even ready to accumulate it. Correct. So people start.
Just listen to my brother.
See, still the mindset would be this incident, even if reported, there will be some reservation that such an exploitation caused to a young boy itself will be something. The reservation will start from that. Then the trauma, fear of the victim, social conditions, the mindset.
The absence of a possibility of a false implication in this kind of allegation, you see. You may have 326 married to 307, etc. But these kind of things, one has to be very, very careful. They will not.
also on the statement of the child, the victim, and also the evidence report.
You show the child's evidence also.
I have child's evidence ballots. Once the child's evidence ballots, I also wanted to show the 161, 164 ballots.
No. Show first the deposition.
Please ballots.
161 only for contradiction.
Child statement is connection P8 minus page 22.
Show that.
Which as it's in question answer form.
PW?
PW 4 minutes.
4, yeah.
Also, will have page number 23 where the statement starts.
Yes.
So and so live in the neighborhood. Few months ago, while I was sleeping under the neem tree at that time, he came and by waking me up, told that he will give me 5 rupees and took me away with him and committed wrong act with me under the tail shade. They both inserted their penis inside my eyes from the back. First, so and so committed the wrong act, and then so and so took the turn, committed wrong act against with me. But he had earlier also committed wrong act with me, and he had committed wrong act with me many times. He used to threaten me not to disclose it to anyone, else he will kill me. Out of the fear, I did not disclose it to anyone. I used to have a lot of bleeding and also severe pain. Earlier, he used to take me.
Read further.
Earlier, he used to take me to his house and commit wrong act with me. One day, so and so took so and so also with me, and both of them committed wrong act with me. And but due to severe pain, I screamed out. And on hearing the screams, my parental aunt so and so came, and on noticing her, both of them fled away. But I got deterred. Then I narrated the entire scene to my brother, and he had disclosed to my paternal aunt. My mother had gone to the maternal uncle's house. My father had gone to Kaila Devi. Then our family got a case registered. Police came to me, and the statements were recorded.
Now, what is the cross?
Well, the cross.
There's
nothing material cross.
What is the question?
The argument being.
The Hindi version has "Dar ke mare." That is missing in the translation. Though the fear is.
Statement from 161, 164 is improved to the extent balance he has added an incident, prior incident balance to the statement for the court.
That is probably missing at page 26. That's what we were just discussing. मैंने डर के मारे किसी को भी बताया नहीं.
Yes, ma'am. He tells his brother, ma'am, who instead tells the mother.
Later, because there was a visit by them, when they ran away on seeing the relative, then he said he confides it in the brother. Absolutely natural. Sole testimony. All that we have to make sure is, are we alive to the situation that is an interested party, not an accomplice, and then no corroboration needed. Sole testimony, inspiring confidence. That's all is the law.
Well, it's my if you kindly consider there's no other witness balance to this entire 5-year-old child. Well, along with that, well, the only cogent evidence is the FSL report. Well.
See, you see, before that, the child, how old was the child when he deposed?
He was 5 years old.
If I look at the McNaughton's test, the questions correctly answered. See that question, you should read that.
5-year-old child improving his statement materially from 161 to the statement for the court. There's material improvement in the statement itself. So
you see the questions put to the child, preliminary questions. Whether one should speak truth or lie. Whether one should speak the truth. What happens when he speaks lie?
Well, if you kindly consider, well, he must have been scared, but the mother itself was out of station, had gone to her maternal house. 2022, nobody calls her and even informs her that so and so incident has taken place with the child. Well, she is unaware of the incident till the time she comes back to the house. Well, even otherwise, well, the uncle starts with a false statement saying on the date of incident, when I came back, my wife told me so and so. The wife says, I personally came to know about the incident 3 days after the incident.
That the child's testimony now, and we have inspires confidence.
Well, the sole child's testimony, violence without any corroboration.
Impugned order also is a well-written order. Just see.
Please, It's, there's no corroboration with the child's evidence. Well, there's no witness. There's
not required.
The only evidence being the FSL report. Well, the FSL report also is defaulted because of the seizure. Well, doctors
got away with 3 years because of you're also minor at that time. Having heard.
I'll kindly consider just not with me on the merits. I've already undergone 2 years. And there was which will have.
No, you cool your heels for till you complete 3 years. Having heard learned counsel for the.
There was a settlement between the parties, which was also told in the High Court, which is also recorded in the High Court's order. Page number 4 of the MP notable.
Not compoundable.
It is not compoundable, but the highest being 3 years, I have been given 3 years. What can be considered was the sentence. I am not in the merits, at least on the sentence.
No, these are offences against.
Actually, they have already undergone 2 years. They have been in the correctional home. Complainant per se has settled the matter. I agree, it is not compoundable. It is a heinous offence.
It makes it worse. It's all you see economic necessity.
They were neighbors, and there is some enmity because of which this case have transpired. What I am saying too, they have already got
misplaced sympathy will send a wrong signal if you go
on the sentence. We consider probation for this matter.
Having heard learned counsel for the petitioner, we see no ground to interfere with the impugned order, especially if petition is dismissed. Yes, thank you, thank you. You placed the case well, thank you. Why did you not file the original custody certificate? Is your Wakalatnama attested by the jail superintendent? It is. The Wakalatnama, jail superintendent attestation. File that one.
The custody was not given to us, so that is why I filed an exemption application for the custody.
But what is the proof today that you are in custody? You come at 2, we'll see the original file whether he is in custody. Just for checking.
He is in custody since studying the papers.
No, we trust your word, but we need some proof. No, you have not filed the custody certificate. All that we can see is whether the who swore to the affidavit here.
Father.
That's the problem, you see. So the only thing we can have is the Wakalatnama. Whose Wakalatnama? Must be his Wakalatnama.
The
accused Wakalatnama. Attested by jail superintendent?
Yes.
Have you got the copy? Correctional home. That is superintendent correctional home.
Correctional.
But now he is in jail, you said, na? This is of Ashish. Where is that Dilkish?
Both the Kalatama there.
Dilkish also there.
Say, superintendent. Correctional.
All. No need. Dismissed.
Wait, please, my lords. So this is a case of circumstantial evidence, my lords. On the same set of evidence, my lords, accused 3 and 4 were acquitted by the High Court, my lords. There was one person, PW2, who was a contractor, my lords, who according to whom was the last seen theory, my lord. That was disbelieved by the High Court on the ground. That incident happened in the morning, it didn't inform after 20-30 days informal. So that was disbelieved, my lords. Now, this accused number 3, my lords, the allegation was that he had taken the mobile of the victim, my lord. That was disbelieved. Accused 4 was the person who had actually brought the car Indica, and all 4 of them were in that car, my lords. He was also let off, my lords. Against me, my lords, what the High Court said at page 24, my lords, is that I had actually got some jewelry, my lord, and had placed it. And had got
PW10.
PW10, yes, yes, at page 24.
Show one by one circumstance and show that.
My respectful submission is the chain is not complete. First of all, the person who saw it has been disbelieved by the High Court on page 14 to 16.
PW2 saw A4. A4 never got into the house.
PW2 has been disbelieved.
He saw A4 park the car,
yes,
and 3 of you go into the house.
And it's been disbelieved, 14 to 16. Please have a look at page 14.
And go one by one on recovery.
Yes, yes.
Recovery of that jewel pawn.
Yes, jewelry is at page 24. Now, page 14 is PW2, my lords. PW2 is the contractor from so-and-so village. He deposited on 39/2013 from 10:15:11 am. He visited Chikkana Ali to supervise the school building construction, the contract of which he had taken. He says that when he was near the school, he found one silver car, Indica car in front of the house of one Somashekhar.
This is para?
Reading minus page 14 at the bottom, it starts.
Yes. Para 14. Yes.
Indica car in front of the house of one Somashekhar. 3 out of the 4 got down from the car and went into the house while the other person remained in the car. He further reported at 1 p.m. he came to know the murder has taken place in Chikkanahally, and when he visited the spot, he found that the murder had taken place in the house where those strangers entered. He further reported that so-and-so police showed him accused number 1, my lord. This is 1910. The incident is of 39, my lord. This is relevant. Accused number 1 to 4 in the police station and identified accused.
What is the time gap between last scene and the recovery of the body?
Well, the recovery of the body is later, my lord, but this, as far as PW2 is concerned, he also did not inform the police immediately. He informs very late. So he has been disbelieved by the High Court, my lord.
No, if I see 3 people entering into the house, I have not seen the crime. I don't know what they will do. They will have a cup of tea and go back. Show that.
He's been disbelieved, my lord, who want me to come to directly to that page, my lord. That's at page 18.
818.
Yes. In light of the above observation of the Honorable, the trial court was not just relying upon the evidence of PW2 that he was a witness to the last scene. So he has been disbelieved, my lords. So now see accused 3, my lords. Now how it has been disbelieved, my lord. Sorry, how he has been acquitted, my lord. That is at 18 itself, my lords. Now again, accused 3 was that he had taken the mobile of the victim, my lords. According to the prosecution, my lords have that. According to the prosecution, accused number 3 on his voluntary statement, so-and-so produced the cell phone of the victim brought by him. It is further case of the prosecution that on his arrest, the IO seized mobile phone, so-and-so, MO 26 from his person in the police station under Madar Exhibit P6 in the presence of Panchas P7 and P8. It is no doubt too that PW7 and PW supported the proceeding under the Madar Exhibit P6, but the material object MO 26 seized under Exhibit P6 at the instant which should be connectable to the crime. Firstly, there was nothing to show that the mobile phone MO26 allegedly seized from the custody of accused 3 belonged to the victim, nor it was the case of the prosecution that the said mobile phone belonged to the accused or was used in the commission of the offence. Therefore, the recovery under Exhibit P6 nowhere connects accused 2 to the crime. So far as recovery of MO cell phone which allegedly belonged to the victim, it alleged that after robbing the victim, accused number 3 had taken the same and concealed the same near the house of his sister. It is further contained in Exhibit P9, P15 voluntary statement, accused number 3 volunteered to show the place of concealment, led PW7, PW8 and IO PW28 to the said place, produced MO5 and same was recovered under Exhibit P20. Even though PW7 and PW8 supported the proceeding under Exhibit P20 as per prosecution itself, MO cell phone was not standing in the name of victim. According to PW25 PSI, who was deputed by PW8 IO to collect the address of the owner of the said phone, states that the said phone belonged to one Nagamma, and as per Exhibit P50, the customer's declaration said phone was purchased by one Nagamma. Though it was contained, the accused number 3 had taken the same from Nagamma and using the same said Nagamma was not examined. Though PW5 says that he collected the CDR date to said phone, the called as produced in this case was not accompanied by the surveys required in Section 65 of Evidence Act. Therefore, they were inadmissible. Thus, recovery allegedly affected the incident.
All right, show that PW10 and the jewelry of the lady.
That evidence is
Tejashwini.
156, my lords. PW10.
No, in the impugned order, how
will
it is?
Impugned order, page 24, my lords. Para 27. PW10, the pawn owner also consistently deposed that since accused to, so my lord, knife was also recorded in the instance of accused number 1. I am accused number 2. Used to visit his shop, he is acquainted with him and on so and so accused number 1 and 2 came to his shop representing that they need money for some medical emergency or friend. They placed the above gold and silver articles for rupees 1 lakh and he paid the amount to accused 2. He further deposited and so the police visited the shop along accused number 1 and and on because he produced the jewelry. So my ritual submission is why this chain is not complete. I'm just pausing here for.
Sir, jewelry was subjected to the identification.
The evidence is in PW10. Just have a look at PW10 also. It's at page 156, my lords. He says that I don't give. So my lords, how this chain is complete?
Page 156.
Yes, is the evidence, my lords. But my lords, before going to that, about my ritual submission is how this chain is complete.
We keep the chain in mind. We keep Sharad Birdichan Sharda in mind.
So grateful.
Anumant in mind. If you
Yes,
want to go back to
I'm
Anumant.
so grateful. To
Yes.
Yes. Yes.
Yeah.
So he says that, my lords, in the cross-examination, at 160, I've kept the jewels for security and given one because one of their father over the phone told me that their friend was not well. I took all the ornaments by weighing them collectively. I did not weigh individually. I cannot say what was the market price of 72 grams of jewelry. It is true that usually while pledging the market considered, I brought 1 lakh money from home and gave that amount to the accused. I do not remember, he doesn't remember that how the denomination of 1 lakh rupees was given to the accused. Given a statement, I have informed that I have given 1 lakh to the accused and the accused number 2 came to a shop for the
No,
first.
you link the jewelry to Tejaswini. What is the link for that? The jewelry is one of the robbed jewelry from the.
Robbed jewelry of the victim, my lords, of the deceased Tejaswini, my lords.
Because you see, you are familiar with Tejaswini. One of you was a driver of the relative of Tejaswini.
Yes,
you have been there.
Yes, that is accused one.
And you went there when all her husband and children were away. You also were received. And then murder is done and jewels are missing.
Yes, and that was accused number 1, my lords, who was acquainted with the deceased, my lords. Now,
what is the identification of the jewelry?
My identification is by PW15 and PW1. PW1 was the husband of the
deceased.
PW15, my lords, is the son of the deceased, who was at that time a small child.
Husband identified jewelry.
Husband, yes, my lords. I have to refer to the court, my lords.
So today, who all stand convicted?
My lords, 1 and 2. My lords, 1 was the person who was acquainted to the deceased, my lords. Now 3 and 4 are acquitted, my lords. 4 was the person who brought his car, my lords. And 3 was the person who, the allegation was that he took the mobile phone of the victim, my lords. So, my lords, it's a case of 34 prime magistrate.
All right, because it's circumstantial evidence, we will issue notice.
Okay.
Issue notice returnable in 4 weeks. You are surrendered, no?
Yes, my lords. I'm inside for, I'm already inside for 7 years, my lords.
Let's
make it serve the standing counsel, my lords. Leave it to serve the standing counsel.
Returnable in 4 weeks.
So great. Well, it's just liberty to serve the standing counsel.
Liberty to serve the standing counsel. Condone.
So great.
In item 16, I'm led by Mr. Sudhanshu.
16 you want to pass over? I was sitting here with this is Girija Shankar Sir. This is the second appeal from Orissa, no? All right, we'll see the passover. All 31. 31, you know.
So this is coming up fresh.
Yes, Mr. Yes.
Because the 2 eyewitnesses have already been examined and they've gone hostile.
They have said, both of them have said your deposition is there saying that
Yes.
he is not the person who shot. Too readily, if they oblige, you get a suspicion.
Case.
The 4th line, he says he is not the person who.
Yes.
Then the prosecutor says, hostage. Show the evidence.
Yes. We just have page 98. It is Mahesh Saini.
Anyway, question is whether you were behind that Vikas shooting. Who shot?
There is another person called Dhamal.
Dhamal.
Now, Dhamal is the person who shot Aditya.
Dhamal.
Admittedly is the person who was holding the revolver or the pistol or the
You see the evidence of this PW4 Mahesh, son of Hukum Chand. I have seen the accused present in court, remaining accused were in custody. These are not the persons who have come. How many undergone?
3 years, 1 month.
And how many total accused?
Total accused, apart from me and Dhamal, there are 14 other persons. So total
4 are on bail.
All 14 are on bail except for Dhamal and me. So I'm not for Dhamal. Dhamal is the person who actually shot. And
you only had that altercation in that dance, I think. What is that? Some
other seat, the passenger seat in the car, which came out. And Dhamal was the person driving. He came out and he took the revolver. He shot it earlier. And supposedly the allegation against me is that I shot the complainant, Mahesh. But Mahesh has not suffered any injury. There is no recovery of any weapon. There is no recovery of any cartridge.
Anyway, the other witness also has turned hostile, is it?
Yes. Dinesh has also turned hostile.
No witnesses. Do not turn hostile. Notice to turn up. Okay, next witness. Show the next witness.
Next witness, Munoz, is Dinesh at page 102. Similar testimony, Munoz. I have seen accused and remain accused. These are not those persons who had come to Sati Colony and opened fire upon me and persons present with me.
Anyway, let notice go. 3 years, is it?
Here's one.
Because of these 2 witnesses, let's see what the state has to say.
Because there are 2 other eyewitnesses as well.
Examined?
Those are not, those have not been examined.
Let us see, we can fix some schedule for that.
Yes.
Issue notice returnable in 4 weeks.
Grateful.
There is one, this is 31, no? We can go to Passover. Before we go to after notice, we go to Passover. Seven is State of Punjab West Sukhdev. Mr. Vivek Jain must be on the way. Let him come. Passover again. You should put Mr. Vivek Jain's name, additional education. He wants to deny interest to somebody. We'll fix it today. Yes, Mr. Item 9. Yes. Item 9, nobody? Who's advocate for Sanjeet Chawla? Passover again, we'll call that at 2 again.
Learned Solicitor General has to appear in this matter. It's still on play.
We'll wait. Passover. Yes, Mr. Agarwal.
Municipal corporation is before your lordships.
Yes.
High Court, which directs us to grant the building permission to the respondent.
Yes.
Now, because what happens in this portion?
With all good conditions that see the documents of title, but don't insist on something which is impossible because you have not, from time immemorial, conducted that survey. Now you answer that point.
So what happened during the hearing before the learned single judge? The Advocate General, the Secretary was called to court at 3 p.m.
Yes.
Lordship will have at 92.
92, yes.
Yes.
Justice Purnendu Singh Sabha.
Yes, Mr. Para 13.
Para 13.
Page 92, Melos internal book of completed page.
Yes.
Lordships have that.
Yes. Yes.
The Additional Chief Secretary, Revenue and Land Reform is directed to personally appear before the court at 3 p.m. to clarify the status of topo land and jurisdiction of the circle officer. Now later at 3 p.m. Lordships. In compliance of the direction in the pre-recess session, the Additional Chief Secretary, Revenue Department of Bihar has appeared before this court and is represented by additional sworns. He further submitted that as all surveyed lands in the state belong to the government, no individual can claim ownership over unsurveyed land, but government is contemplating to announce a policy in regard to topo land on which topograph survey has not been carried out. The state government is bound to give ownership rights to all citizens who have been living or carrying out agricultural activities on the topo land in districts such as Khagadia, Lakhisarai, Saran, Samastipur, and other districts for the last several decades, for which they have also been paying taxes for the land to the concerned department since then. Soon a policy decision in this regard to create Jamabandi in the name of persons who are inhabiting the topo lands by constructing their dwelling houses or are agriculturists and running their businesses and
let him also construct and let him also be given later. Why should he be? You see, look at the condition hedged in the operative part of the order.
Lordship will come to that first. Lordship, before that, could your Lordship just have a page number 121?
Yes, you go in your own way.
I understand. Lordships take it that this, because the government is at fault in not giving him the rights, Millers. But
they will have to have a roof over them. Otherwise, you see.
What happens is if these things happen, Millers, it becomes very difficult for us to control these, which are
it has happened for so long for others.
Yes.
What is his name? Petitioner?
The Municipal Corporation Saran, Millers.
No, what is the petitioner?
The writ petitioner, Shyam Sundar.
Yeah, when Shyam Sundar goes, you say now all this, objections you raise. You show the page you wanted to show.
I just wanted to say, Millers, page 121, para 52.
Yes.
It is admitted fact that entire city of Chhapra situated on topo land. Because topo land is a land between where the river recedes or comes back. Sometimes that land becomes free. Like even in Patna, Ganga has receded a bit.
Yes, yes.
That becomes topo land. Now, suppose somebody is claiming that I have a right to construct there. The government says, I don't know whether this land can be given to you or not, or it can be because you have to show possession. Now, they have sale deeds, etc., which the registering authority registers because they don't look at somebody.
According to them, the river must have then expanded initially. And inundated lands, they would have, now when it has receded.
Yes. These people are there.
Unless you have a policy like Maharashtra that if it is a riverbed,
yes,
you can't have construction for up to 50 meters.
Correct,
Something is there, 100 meters.
Absolutely.
Under the Act.
Right, Bilal. Now, today, Bilal, suppose on what basis today a government, the municipal corporation is.
But here it is not a riverbed, it's only Chapra. Whole of Chapra is like this.
Chapra is a problem. Now, Bilal, the government says that you please, the High Court says you please grant building permission to them.
No, see that operative.
Yes, Lordship will just come to straight away to that, Bilal. Page number 127 at 59.
But I think the Deputy Auditor Justice Ashutosh has reiterated that.
Yes, Bilal, yes. Lordship, sir, para 59.
Yes, 59.
I accordingly hold that the building plan of the petitioner having not sanctioned in the name of the petitioner by municipal authorities contained in so and so is without authority of law, which calls for.
Just 1 second.
Oh, sorry.
Yes.
I accordingly hold that the building plan of the petitioner having not sanctioned in the name of the petitioner by municipal authorities as contained in so and so is without authority of law, which calls for interference under facts of the case and laid down by this honorable court and the apex court. As such, the order so and so is set aside, quashed for reason, taking into consideration information given that steps are being taken, the same be done within a reasonable time, at least in respect of Chapra town, where township has existed for 100 years and perennial alluvial and disillumination has stopped due to change of course of river. With those directions, it is disposed of.
So, what all should be produced?
Because that whatever documents is produced, you accept it. Because what happens? Because if it was land which belonged to nobody, this land belonged to nobody. So
no,
if we have,
in fact, if you
without page 127, para 58.
Yeah, just see that.
The ground, same page, just one page.
Yes, yes.
The ground of rejection is that the junior engineer, upon verification of the checklist attached with the form for grant of approval of building plan, had found the same did not contain the rent receipt, LPC it's called in Bihar, land possession certificate, and other documents pertaining to the said land duly issued by the concerned circle officer and had recommended for rejection. On the perusal of Form 2 and Conditions Clause 5(4) of bylaws and the checklist contained in Form 6 and the conditions of so-and-so bylaws, I don't find that objection raised by junior engineer that the petitioner has not produced LPC, Jamabandi rents, so-and-so are not required. The commissioner has not given any consideration of Form so-and-so and in most mechanical manner has accepted the recommendation of junior engineer. Stopping here.
No, there is one para where he says, produce the
yes,
X, Y and Z document.
Because he, that lordship may say,
give me the hard copy of this paper.
In the facts, I don't find
hard copy.
Lordships will one page previous to one page 124. Your lordships are
yes, just have 124.
Yes, lordships has said these are the documents which are there in the form, checklist forms.
Yes.
And in these documents, Milos, what the High Court says is that there is no requirement of LPC, rent receipt, etc. because this is the checklist of documents.
Yes.
And therefore, you proceed on this basis, Milos. Lordships, what your lordships have held that also that your government, what your lordships, I know what your lordships are saying. If the government is not giving them the rent receipt, how can the municipal corporation insist on? Is that something your lordships had in mind?
No, taking into consideration, there is, he says, produce the documents with you. Where is that?
No, that's the checklist, Milos, at page number 124. Milos.
I see.
57.
57.
Yes, Milos. Yes, sir. And what the High Court says is, the question is at page 110, para 39. Why the High Court holds against me is at page 110, para 39.
Yes, yes.
The question arises whether in a situation as of present, state government, after allowing topo land to be registered after registration in favor of petitioner, can at the same time by a policy decision prohibit the mutation and direct circle officer to not create Jamabandi and issue LPC. And as a consequence of the same, in absence of required documents, the municipal authorities can refuse to sanction the building plan till the state government takes a policy decision as informed by Advocate General. So what the High... Sorry.
No, 1 second, 1 second.
So no, no difficulty.
Correct.
Perhaps page 4, para 6, your lordships are referring to the
Yeah,
division bench order.
yes, yes.
The division bench order.
Division bench also.
Under the circumstances, order passed by refusing to sanction building plan was set aside. Learned single judge has taken note it be sufficient if documents are demanded from the respondent, which would.
Where is this para in the single judge?
That's what the single judge says, that your lordships goes back to the single judge. It says that if you have page 127, para 58.
Yes.
That's the interpretation of that. The ground of rejection is that the junior engineer, upon verification of the checklist attached with the form for grant of approval, had found that the same did not contain rent receipt, LPC and other documents pertaining to the said land duly issued by the circle officer and recommended for rejection.
Let us hear on Kevin. What do you want to say?
Not the same.
They have objected to the building plan since 2017, and I'm not the only one who's aggrieved by this. There are other people, my lord, and this matter will have implications on the entire district. So far, the policy is concerned, my lord. They had there are newspaper reports in 2023 that they are considering a new policy. However, so far they have not done anything. Now, my issue, my lord, is there is a concurrent finding by the division bench. Now, what has happened, my lord, in the meanwhile, after the judgment of the division bench, I have already started my construction. Now, monsoon is arriving. This SLP has been referred here before this honorable court. Now, there is no order from this honorable court. Even then, I have been stopped from constructing anything on my land. I am not even allowed to construct a retention wall, my lord. That is my concern.
So what? Nothing is. Having heard.
Is it possible to?
There is a concurrent finding by.
The thing is, we are worried about it because we'll be now having house.
You have to legislatively intervene and do something. At the moment, it's free ground. So
that's a difficulty with us.
Having heard learned counsel, Mr. Gaurav Agarwal, learned senior advocate for the petitioner, and your good name?
Neha Singh.
Ms. Neha Singh on caveat, learned counsel on caveat. We find no grounds to interfere with the impugned order. Especially petition is dismissed.
Grateful.
You take steps in contempt or something if they are still objecting. Yes.
My apologies.
Yes, Mr. Jain, we have been waiting for you. No problem. I know you'll have matters, but what is going on in your state?
We are not, as far as even catchment is there, it's been granted. Gratuity has been released, retirement has been given. The only question is whether the interest has to be given or not, which I have covered judgment, your lordship. It's a direct judgment on your lordship. In fact, the similar provision in Andhra Pradesh, it came to be tried before.
No. When was the charge sheet issued?
Charge sheet was issued in 2011.
When was it dropped?
Dropped in 2018. As soon as it is dropped, we have released every.
So who is at fault? Who is at fault? Let's see the judgment. We will deal with it. We will strike it down here and now as manifestly arbitrary. Just come. Give the judgment.
Yes. The similar situation, madam, where there was a provision which is there in the pension rules. And if your lordships would have para 7,
No, show whether it was a case where it was dropped.
If your lordships would see para 7 of this, your lordship.
Yes.
The payment of gratuity was withheld in the present case since the criminal prosecution was pending against the appellant when he retired. Rule 52(1)(c) of AP revised pension rules expressly permits states to withhold gratuity during the pendency of any judicial proceeding against the employee. In the present case, apart from 52(1)(c), there is also an express order by tribunal which is binding on the appellant and the respondent.
No, gratuity, you see, gratuity No, criminal proceedings must have ended in acquittal, etc.
Also, there was a criminal proceedings.
Both were dropped. This is fault. Why can't we order compensation?
In case it was to be decided in my favor, I would have to recover it from. That's why this whole provision is there. And in fact, in this.
No. If you had let the charge sheet go through the full hog, and even if you have, exonerated him or whatever it is, depending on the.
It was dropped because there is a criminal prosecution which got dropped. So therefore, this is dropped.
That also got dropped. This also, or same charge. What was the charge?
I suppose that he is awarded tailored to a person who is given a higher bid when the lower bid was available. And the parent lost around 9 crores, which obviously Malak is not concerned about, but that's the case.
Nobody will take decisions if you. So obviously somebody has victimized him. How much cost now? We are waiting for you.
There was a provision I am going to see your lordship. I just read it further, this judgment, your lordships. In the present case, apart from so and so, then your lordship see classical G. In view of the order as well as view of 52(1)(c), it cannot be said that there was any illegal withholding of gratuity by the respondent in the case of appellant. We therefore do not see any reason to order payment of any interest on the amount of gratuity withheld.
That is because the prosecution continued.
Case also, there is a similar provision, 2(1)(c), which we cited before your lordship.
Having heard Mr. Vivek Jain, Learned Additional Advocate General for the State of Punjab, we find no grounds to interfere with the impugned order. The special petition is dismissed. Anyway, because it's state, in this case, will not impose costs. Yes. Passover 9, you withdrawing? Let's see what the matter is. Oh, this is the Delhi High Court order. You were sitting in Canada and you wanted to after withdrawal again appeal, etc. All right. Ms. Manjeet Chawla, Learned Counsel for the petitioner, seeks leave to withdraw the special leave petition. The special leave petition is dismissed as withdrawn.
Learned solicitor.
Yeah, we'll take it at 2 o'clock. 2 o'clock. 2 o'clock.
Lordship, may for a short date.
All right. At the request of the respondent, list the matter next week.
Lord, let them file a reply.
No, we are inclined to issue notice in the matter. Anyway, he has some time. We don't solicit it.
In the afternoon, this has been happening for the
No. Solicitor is held up. We'll have it next week. It's a validity matter, 79-page order. Detailed order has been passed. We've seen parts of it. Yesterday, we had a similar case. We may not give any interim order, but anyway, then next bench will take a call.
Lord, I am not pressing for an interim order, Lordship.
No, my lord, I am opposing it. We have been opposing this round of litigation has closed already. They are seeking to reopen it now.
All right, next week, we already adjourned it by next week. Yes, 16.
Wait, please, Milords.
Yes, Mr. Padman.
Lords, the issue involved here is, Milords, can I file a suit for injunction simpliciter, or whether I have to file a suit for specific performance before that?
We'll take it at 2. You are not filed a specific performance and you are sitting on 53A. That's right. That also is disputed. We'll come at 2 and take it up. All the. You convince us that how without filing a specific performance, you are going on merrily. Hello? Yes, Mr. Pad.
Wait, please.
After this, we take 1 and 2. Last pass of 1.
Before Millards rose, Millards, I addressed a question, Millards, as to why did you not file a suit for specific performance? My answer to that is simple, Millards. I should have. I cannot run away from the fact that I should have filed it. But what were the circumstances in which, Millards, the present suit came to be filed? Millards, in 1996, Millards, an agreement is entered into between the petitions before my lords and our own uncle, Millards. Millards, the agreement mentions, Millards, consideration. Agreement mentions, Millards, possession is being granted. And, Millards, agreement also says, I must fairly point out to my lords that if at all the permissions are not obtained for the lease, for the leasehold land, a suit can be filed for specific performance. It says so. That's what's against me. Till 2008, Millards, I continue to remain in possession, Millards. In fact, till date, for 30 years, Millards, I'm in possession. I am collecting the rent for, Millards, the tenants who are residing on the premises, Millards. What happens in 2008, Millards, is, Millards, according to me, Millards, the vendors who are my own uncles threatened to dispossess me or to, Millards, sell the property. That's when I filed the suit, Millards. In the suit, the only relief sought is for protection of my possession. Now, the question before my lords is this, that can I file only a suit for possession without seeking a suit for specific performance? In my humble submission, my lords, 53A of the Transfer Property Act is an answer to that.
Read 53.
Yes.
And even there, the finding is against you, but we will see that. 53A part, but let us see the section.
Very well. Lords, it's in the appendix itself, Millards. Page 53, coincidentally, Millards.
Yes.
53A. Mr. Varale has it. Page 53, Millards, it's there. Page 53 of the SLST.
Always better to look at the book for a section.
Very, very good. Right.
Yes.
So we have place 53A, Millards. I'm of course placing from the SLP paper. Where any person contracts to transfer for consideration any immovable property by writing signed by him or on his behalf, from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty, and the transferee has, in part performance of the contract, taken possession of the property, 1 minute, or any part thereof, or the transferee being already in the possession continues to in possession part performance and has done some act in furtherance of the contract, and the transferee is performed or is willing to perform the part of the contract, and notwithstanding that, where there is an instrument of transfer, the transfer has not been completed in the manner prescribed thereof by law for the time being in force, the transferor or any person claiming under him shall be debarred from enforcing against the transferee and persons claiming under him.
Transferor is debarred from enforcing.
That's right.
So he files a suit for recovery, you can assert your possession. But otherwise, your agreement, what interest will it create? How will you assert a right based on a mere agreement to sell? And the fact that you have not said now, even on part performance, what is the finding on 53A?
Just one thing, Millards. 53A, what Millards is putting to me is like a shield, Millards, that I can use it as a shield in any proceeding against me to protect my possession. But Millards, the full bench of the Honorable Bombay High Court has taken a view, Millards, that even a suit can be filed.
What suit?
A suit simpliciter for injunction. That's the finding. Millards, may just place that for on law, Millards. Millards, may kindly have the full bench judgment is part of the SLP, Millards. Millards, may sign off.
First show the finding on 53A, how that was negated.
That's right. So Millards, may show the trial court finding or
you go in whichever way you want, but show the finding.
Yes, Millards. Page 179, Millards.
Yes.
Millards, this is part, Millards, of annexure 25. P25, since Millards will be referring to the online.
Yes.
It starts at 161.
Suit was also dismissed. Appeal is also dismissed. Let us see on 53A.
Yes.
What is the finding in both?
Page 179. My lord, this is Varale has it. Yes. It's, Millards, it's not numbered. There's a parallel. Somewhere in the middle it says the benefit of section 53A.
Yes.
Is to be provided when transferee must prove that he has performed or is willing to perform his part or contract. In the instant case, the plaintiff filed his suit seeking injunction against the defendant that admitting the fact that defendant is having right title interest over suit land. Section 53 specifically says the rights of transferor expressly reserved in the contract. It has to be pointed out that transferor or any they say that they paraphrase it, and they answer it at page 184 minutes.
Yes.
The second last paragraph, it says, by way of the simpliciter suit of injunction, the ownership and declaration regarding title to the property cannot be done. They completely, according to miss the wood for the trees. Neither the same is the domain of the suit. It is further needless to mention that the plaintiff to succeed in the suit, he has to prove the contents as mentioned in the plaint, showing his right title interest in the suit property. There is nothing on record to show the plaintiff was having any right title interest in the property. May kindly have thereafter, I have considered relevant law section 41H of the Specific Relief Act, where it mentioned an injunction cannot be.
No, you come to the para 18 of the impugned law. Take off from there.
Very well. It was page 20 perhaps of my lord's paperwork.
Yes.
Coming to the provisions, my lord says.
Yes.
Coming to the provision under section 53A of the TP Act, on reading the judgment passed by trial court to agree with the contention advanced on behalf of the plaintiff appellants that the amendment affected in the year 2001 to the Registration Act has not considered its proper perspective as much as the agreement question was executed prior to the amendment. The trial court holds
you can come to 22 from the language.
Yes. From the language employed in page 22. From the language employed in the provision, it is abundantly clear it's a question of fact to be determined on the basis of evidence in a case. Here, the defendant has disputed the existence of agreement. In addition, had taken a specific plea that the mother of the plaintiff was interested in look after shop rooms in the premises to collect monthly rent. So therefore, Millard's position is admitted. Under such circumstances, when the possession of the plaintiff itself is disputed, it is for the plaintiff to adduce cogent evidence to prove the same. It is nonetheless to mention that the plaintiffs are well free to do so. Now, Millards, there is not even a single finding in the trial court or in the appellate court.
How much consideration according to you was
maximum?
What is the property?
It's a small property of around 4,200 square feet of
land. Under the agreement, what is the consideration?
2 lakhs under the agreement.
And the entire 2 lakhs paid.
2 lakhs paid. And the first appellate court, in fact, holds that I'm in possession, Millards. Page 205. It holds that I'm in possession, but it goes into the aspect that maybe you are in possession for collecting rents. Therefore, Millards, we kindly have the final finding of the High Court at page 25.
Tenants are occupying it.
Tenants admit that I am giving the rent to.
No, correct. But constructive possession, there is no physical possession. There is no physical possession. Constructive possession is there.
Now, may I respond to that?
So then you are claiming only under incoherent the interest on basis of an agreement without instituting a suit for specific performance.
3 things, Millards is putting me that I am claiming on the basis only of an agreement. Now, may I respond to that, Millards? 1. Under the agreement, Millards, there was a requirement, Millards, for them to apply to the government for change of leasehold land. They do so.
That doesn't stop a specific performance because any permission obtained, decree will be subject to obtaining the permission.
I'm taking it against you, Millards. I did not file a specific performance. Whether 53 I can make out or not.
Yeah. To show the Bombay judgment, is it based on the agreement of specific performance, the agreement of sale?
Yes, Millards, may kindly have the agreement, the Bombay High Court judgment, Millards, 55.
And was it a case of constructive possession?
Please, may I just please?
Yeah. See, show the facts in
bench judgment.
Yes.
Page 56 is the issue frame. Para 1 minutes, may I have?
Yes.
The Honorable the Chief Justice constituted this bench for consideration and decision on the following points. Whether a suit simpliciter for injunction which is filed seeking protection under 53A of the Transfer Property Act is maintainable. The facts giving rise to reference are: 1 so-and-so, present respondent, filed a suit seeking decree of perpetual injunction from disturbing possession. The case for the plaintiff, Millards, may kindly mark it, Millards don't mind, is that on so-and-so an agreement of sale was entered into between the plaintiff and defendant for sale of 2 acres, so-and-so, so forth. And my lord, this is answered, my lords. If my lord may see the answer on this at page 67, my lords. Because after there's a quotation, it says, in our opinion, because that's the bench, honorable bench speaking minutes. Page 67, my lord says. In our opinion, even if it is assumed that the cause of action for instituting a suit for decree of specific performance had occurred, and the plaintiff in that case omitted to institute the suit for specific performance, then also by virtue of order to rule to the suit would be barred. But his suit for a decree of perpetual injunction protecting his position would not be barred.
Now, what is the earlier judgment they are citing?
Yes, my lords. This, my lords, is again, my lords, it appears to be a Bombay High Court judgment.
Single judge.
Yes, but what they rely upon, my lord, is a Honorable Supreme Court judgment, my lord, may thereafter, para 20, the last two lines, para 20, 21 of the judgment of the Supreme Court are relevant. My lord, that judgment is Shriman Shamrao, my lords. My lords is well aware of that law in that. I have that, may just read from here, my lord, let's quote it here. Para 20. It is therefore manifest that Limitation Act does not extinguish a defense but merely bars a remedy. Since the period of limitation bars a suit for specific performance of a contract if brought after the period of limitation, it's open to a defendant in a suit for recovery of possession to take a plea for defense of part performance, but also putting to me. In the present case, it's not disputed that the transferee has taken possession over the property in part performance. It's not disputed transferee has brought any suit for not brought any suit for specific performance within the period of limitation. Thereafter, my lords, the honorable bench holds, it is thus clear. May I read that? After the quotation.
No, you read, it is not disputed that transferee was always and is ready and willing.
That's right. Transferee is always and is ready and willing, my lords, to perform as part of the contract. There was nothing pending on my part. Last paragraph. It is thus clear that in such a situation where a decree or suit for decree of specific performance is barred by law of limitation, the prospective purchaser in possession would not be in position to institute a suit for decree, but Section 53A creates an equity in his favor, as a result of which he is entitled to continue in possession. If it is held that though his possession is protected, he cannot institute a suit in the case, he finds his possession has been threatened would amount to denying a remedy for enforcing the equity which is created in favor by 53A. Now, this is clearly contrary to what the Honorable Odisha High Court has said in the impugned judgment, saying because of 41H, which says that if you cannot grant 41H in specific relief act, my lord says, you cannot grant the injunction if there is an alternative remedy available. Because of that provision, 53A you cannot claim.
Specific performance is not an alternative remedy. No, show the trial court finding on possession.
There is no finding, lords. I may just show that, lords. There is no finding at all, Lord.
Where is your pleading in the injunction suit?
Yes, Lord. May see the plaint itself, Lord. Lord, it starts at page 84, my lords.
Yes.
Let me kindly come to page 85, my lords. Para 2, my lords. I mentioned about the agreement, my lords, that he entered into this agreement. I paid consideration. Page 86, my lords, mark for a moment, my lords. 86, it says, on the same day, power of attorney also delivered physical possession. I plead that, my lords.
There is no dispute on this power of attorney?
Dispute of power. It is registered power.
And what was the stand of the defendant?
Defendant stand first when he filed the written statement, he denies his agreement. But that's held against him by all courts.
All right, then possession.
Lords, as far as possession is concerned, as I was saying, my lords, the Honorable High Court has held, as my lords put it to me, saying that possession is not proved. But who has not proved it? Because the trial court and the first appellate court do not render any finding on possession. In fact, the finding is in my favor.
No, have you set up a plea that even though possession is constructively handed over, tenants are in physical possession?
I've said so, my lords. Lords, kindly mark therein. My lords, may kindly have page 86, para 3. That neither have defendant power of attorney scheme to take effective steps in spite of disputed requests, as the suit land comprised of tenanted premises, the tenancy in respect of those premises are duly attorned in favor of plaintiff in terms of the agreement. Since then, plaintiffs are continued to collect monthly rent. And PW2, my lords, is a tenant who steps into the box and says, yes, these people are in a position and I'm giving rent to them.
Mr. Shubhranshu Padhi, learned counsel for the petitioner, submits that an agreement holder who is in possession of the property pursuant to the agreement is entitled to sue for injunction simpliciter without any relief being sought for specific performance. He relies on Section 53A of the Transfer of Property Act and the judgment of the full bench of the High Court of Bombay in 2004, 4 CTC 465. Learned counsel also draws attention to para 18 of the impugned order, where the High Court has noticed that the property, what did the High Court exactly say?
Page 20 below, the High Court says the suit is not maintainable. Page 23.
He draws attention to para 18. He contends that the finding is erroneous since the property which was tenanted on the date of the agreement, since though the property was tenanted on the date of the agreement, tenancy was atoned in his favor of the petitioner. He also submits that the petitioner has parted with the entire consideration of 2 lakhs. Issue notice returnable in 4 weeks. In the meantime, status quo as on today shall be made. We'll take 1 and 2.
Please.
Yes.
He briefly put this coming up after notice. Not very briefly put, what happened here is the respondent number 2 had a fight with the deceased on 19th. Next day, he along with the respondent 1 went to the house of the deceased, had another fight, 2 fights back to back. 3 days later, charge sheet says that he called one sharpshooter from Rohtak, another village, not involved in any of this couple. He calls one Vicky Karthus, who is a history sheeter. He comes with a pistol and 2 cartridges, 2 pistols, 3 cartridges. He come to their town. Now on 28th, he comes 1 day before the event. On 28th, there is a wedding in the village. Everyone knows that the deceased would also be present. So before leaving for the wedding, they go and test fires. Respondent number 2 test fires the gun. Then at the wedding, they pick up unnecessary fight with the deceased.
Respondent number 2 in the first matter.
Not this.
There's only one matter.
One matter.
Okay.
So they pick up a fight with the deceased and then ask the sharpshooter, Vicky Karthus, he fires 6 bullets, which hit 3 people, or rather 4, including deceased. And there are 3 injured eyewitnesses. So they go to hospital, deceased dies on the spot. Then they abscond, all 3 of them, respondent 1 and 2, with Vicky Karthus, abscond in the car of Yashpal, respondent 1. For 6 months, they stay absconded. Vicky Karthus gets arrested in some other offense. His custody is taken. In section 27, he takes them to Yashpal, respondent 1's old ancestral house, which is in ruins. I'll show that. And the pistol is recovered from Yashpal, respondent 1's house. Then the 2 accused, other accused are granted bail, very important. Other accused are granted bail on the pretext that,
He is the main assailant.
yes, that these three are the main assailant.
Where is that bail order?
Yes, my lord, that's on the record. My lord, may have page 84. 85. There are two orders, not just one. Two orders. 85, para 5. My lord has that?
Yes.
Considering the argument put forth by the learned counsel of the petitioner and looking into the statement of injured eyewitness, namely Vikas and Naveen, wherein specific overt act has been assigned to the co-accused Yashpal, Raman, respondent 1 and 2, and Karthus, which is the sharpshooter, who caused firearm injuries to the deceased as well as to the above two eyewitnesses, and looking into the facts that after investigation, charge sheet has been filed and the trial will take time to conclude when without expressing an opinion, merits of the case deemed proper to grant bail. And then again, 2 pages later, my lord, 87, Om Prakash, another co-accused.
Now, in this case, who are the respondents here of these three? Yashpal and?
My lord, Yashpal is respondent 1 in our case.
Yeah.
Raman is respondent 2. Karthus is not there. He's in custody.
He's in custody.
He's in custody. And again, Om Prakash, who is another co-accused, page 87, he's also granted bail on the same finding that respondent 1 and 2, para 4, page 88.
Page 84, first order. Page 88 is the next order.
Yes, para 4.
Not challenging Om Prakash.
What overtax has been assigned to co-accused Yashpal and Raman?
You are not challenging Om Prakash order.
No, I am not.
You are only subjecting
Yes.
this
Yes.
to Yashpal and the other one, Raman.
Yashpal and Raman. Because they are the one who, and now look at the High Court order. High Court foot pitches its case on 2 footing. One, that co-accused has been granted bail. Co-accused has been granted because you are the main. You are granted bail because co-accused has been granted bail. And secondly, that Vicky Karthus is the one who has shot the fire. Now, this is very important. If a sharpshooter is hired, my case can't be proved. If I hire a contract killer, there can't be that my case is better off.
Now, you keep up this parity. What is the date of the offense?
My lord, this is
28 of November 2023.
Yes,
23.
28 November 23.
And what is the stage of the trial now?
Yes, my lord, only one witness has been examined and eyewitnesses have not been examined.
They are not tried.
Yes, they were in custody. They were in custody for 3 months before granting bail. Only 3 months.
When were they arrested?
Yes.
14/5.
14/5, 24.
24.
Yeah. After co-accused were granted bail, then they surrendered.
And bail released by High Court on?
Within 3 months, my lord.
Filing of charge.
Which is the impugn order.
It's 23/8.
23/8.
Yes.
So the charge sheet, and is the deposition of that one witness on record?
But not here.
Okay. Okay. Show the charge sheet. Show the charge sheet. Show the roll.
Yes, charge sheet, my lord. My lord may have, very important. My lord may have page 133, sorry, 133. My lord has?
Yes.
Yeah, para 1. In this case, the informant party Ashish and his brother deceased and the accused Om Prakash Yadav, Yashpal, Tikku, Kulban, Dola, etc. are resident of this para 2. On 1911, the well of Ankit Singh, child was worshipped in village in which during conversation Aman Yadav had an argument, fight and altercation with neighbor Raman, son of this. Raman told about altercation to his cousin Yashpal, Deepak, another family. Due to this, on the next day, on 2011, there was an altercation between the family members of both the sides, but the villager had consent. Since then, there was a rivalry. During investigation, found that Yashpal, Raman, Om Prakash had gone with sticks. 3. This is important. In this case, Yashpal, son of Deepak, from the accused party, is a lawyer by profession who has been in contact with criminal Vicky alias Karthus, resident of Sandhi district, Rohtak, who is a criminal involved in murder, armed ransom and criminal cases since long. And Yashpal had got bail against criminal Vicky alias Karthus in other murder etc. Cases were going on in Haryana and Delhi, due to which Yashpal.
Vicky alias Kartus, they made it cartridge.
Yes, I know the translation, quite literal translation. Got a fight. Both of them had become friends. Yashpal lawyer brought Vicky Kartus into his village on 22/11 and told him about ongoing rivalry with his villager Aman Yadav, son of Bhagwan. On 8/11/23, Sahil Yadav, son of this was getting married, and his marriage procession going on in village. Sahil Yadav had invited family members. Since Yashpal and his brother Raman from the accused side were fully aware that their opponent Yaman Radhav attending the marriage. That is why, as per the plan of lawyer Yashpal Raman, one day before marriage on 27, their acquaintance Vicky and Kartus came to Yashpal's house with 2 illegal weapons, 2 pistols, 3 magazines. Yashpal and Raman, brother-in-law Sandeep, president of this also came to their house to attend the wedding. Yashpal also, I'll skip next paragraph. That on 28, before leaving the wedding procession in the evening, Yashpal and Raman asked Vicky Kartus to test their tool weapon. Then Vicky Kartus said that grandfather is standing nearby, he will scold. Hearing this, Raman and Yashpal grandfather, who is a former lawyer profession, said that they try firing a firecracker. There is no problem. Yashpal encouraging his grandson, Om Prakash encouraging his grandson, Yashpal and Raman and their companion, instead of stopping them from keeping illegal weapons and firing, makes it clear that the accused are participating in conspiracy, getting permission from the Om Prakash to fire illegal weapon. Criminal Vicky alias Kartu threatened Yashpal and their grandfather and their companion with firing in front of relative Sandeep Kumar. 1 round was fired from the pistol used in the incidents, and then Raman, son of Sanjay, fired 1 round to check the incidents. Then my lord, para 7, next page, my lord. That after the above incidents, lawyer Yashpal Raman from the accused side told Vicky Kartus that among 3 boys who had pushed us, there was the same boy Aman Yadav, whom he had planned to teach a lesson. After this, as soon as
read the earlier para.
Para 6. At the marriage procession, the son Sahil of Ratinam in village this had travelled about 70-80 meters from the school gate to the house of the bride side at about 9:30-10. At the time, Aman Yadav, son of this and his companion this along with all of them, their name are there. Party were also dancing. Then Raman, son of Sanjay, Yashpal, son of Deepak, started pushing and shoving Aman Yadav, son of Balwant, under the pretext of conspiracy, but other members of the marriage procession separated both the parties. That after the above incidents, lawyer Yashpal and Raman from the accused side told criminal Vicky Kartus that among the 3 boys who had pushed us, there was the same boy Aman Yadav, whom he had planned to teach a lesson. After this, as soon as the procession moved a little further, lawyer Yashpal, Raman, Vicky Kartus, Sandeep, Kulwant, etc., all of them again attacked as a part of conspiracy. While dancing and jumping, they started pushing and beating Aman Yadav, and a fight was created as per conspiracy. Naveen, son of Raman, Ramesh, Vikas alias Kala, son of Vijaypal, and Dinesh alias Mittu, son of Satyanarayan, came to the take side of Aman Yadav. Meanwhile, Yashpal's friend Vicky Kartus took out his pistol hidden in his pocket of his pants. As per the earlier conspiracy, fired at Aman, Naveen Kumar and Vikas, which resulted in a fight. All 3 were injured and taken to Sheila Nero and multi-specialty hospital for treatment, but doctors declared Aman dead and Naveen and Vikas were admitted for treatment. Postmortem of the body was conducted. In this case, videography was done in the marriage ceremony of Sahil Yadav in order to clarify the presence of the accused. In this case, wedding ceremony and the incidents of was 6 photographs of the wedding ceremony and incidents were taken out of the photographer Jatinder. In all the set photograph, arrested accused Tikku alias this have been found photographed dancing. The investigation of this case, the available evidence and participation of the accused in the wedding ceremony together confirms their involvement in conspiracy. Incident occurred on this between. So, my lord, this was the act.
All right. Show the impugned order where parity was applied with.
Yes. Now, my lord, I have page 3, para 5. Considering the arguments put forth by the learned counsel for the petitioner and looking to the facts that injured Vikas and Naveen in their statement recorded under 161 have leveled allegation of causing firearm injuries against Vicky Kartus, the general omnibus allegations have been levied against petitioner and the co-accused Sandeep and Om Prakash, whom indulgence of bail has already been granted by the court. Looking into the facts of the case, is par with them, and they are in custody from the date of their arrest and are after investigation charge sheet has been filed. So, my lord, now ground for why bail should not have been done. Bullet points. One, absconding for 6 months immediately after the incident. So itself, if the accused is absconding, that's a ground for non-grant of bail. 2, serious offense, only 3 months in custody. 3, eyewitness not examined. Apprehension of they meddling with the trial, they have hired contract killers. So we are apprehensive that they might influence the trial. 4th, my lord, a case of someone who is hiring a contract killer can't be better than the contract killer himself. He can't be made non-main accused. Then everyone will start.
Who is for this state?
I beg to appear for the state.
So, Padmesh, you have filed a counter opposing, but you have not taken any steps to set aside the bail order.
We have not, I had inquired, we had not filed any SLP challenging the order. And my instructions are to support, the case of the petitioner. Because although, in the trial, the update is that there are 2 witnesses of 32 have been examined. Because there were 2 charge sheets, one had 11 and the other one had 21. And the next date, is fixed for the 3rd of May, 2025.
How many eyewitnesses to go still?
We 3 witnesses, lords.
3. Okay. And what is your stand? You also argue so that they can reply. Since you're supporting, you want to say anything, you.
In support of my learned friend, it's a 302 matter. There are serious allegations of hiring a contract killer who though happens to be in custody. The scuffle, my lords, is a scuffle that is deliberately made out.
How do you bring out that? See, otherwise, if Vicky has just pulled out the rifle and shot, and these are people who are fighting for whatever reason.
There is a design, the presence of a
reason, is it? Dancing, they picked up the reason of dash and they immediately started.
This was an engineered provocation.
Yes,
or
this was an
engineered fight.
Because there was otherwise no requirement of a contract killer to be present at that spot. Now, if your lordship would have the charge sheet, all of their presence at the location has been confirmed. There is no doubt about it. There are photographs, videographs. The injured eyewitness have stated that they are present at the spot. So far as the presence of the accused and the role is concerned, there is absolutely no doubt at this stage, at least at this stage, and the witnesses are yet to be examined. But in a 302 matter, with allegations like this, in 3 months of custody, bail has been granted. And the ground of parity, is absolutely inapplicable. Both the other, in fact, both the other orders specifically record that Yashpal and Raman, the role of Yashpal and Raman is specifically recorded. The other interesting feature, is the second charge sheet, so far as these 2 accused are concerned, which came to be filed on the 12th of August, 2024.
What was read to us?
Yes, that's the second charge sheet, The first charge sheet, was filed on 27th of February, 2024. But this chronology is important, because the other 2 orders are of March 2024. So first charge sheet
made who all the accused?
First charge sheet.
They were shown as absconding.
They were shown as absconding. So the first charge sheet is filed. The co-accused are.
Yeah, okay. How do you defend this order? How do you defend this patently, non-application of mind in saying that in the other bail order, to say that this petition is not the main accused, they are the main accused. And when they come, you say that because I have granted bail to the other accused, I give.
Comes to the order. I need to show to your lordship that so far as the bail which was granted to the earlier 2 accused and to these 2 accused, the allegations are identical. I'll refer to their own number 1. And at that time, I kindly appreciate, because at that time, and before I come to that, kindly appreciate the incident is of 28th of November 2023.
Yes.
The allegations are that there was a fight and while they were dancing on some DJ and gunshots were fired by one of the accused. That's admitted. Now please appreciate not which FIR is registered after next day after 20 hours. Though one person is already died and there are two injured witnesses, out of them one himself is a police officer. And now interestingly, my reference page 137, where it says that 3 persons from their faction came and intervened. None of them is the informant. Who is the informant? Who is not even present there? And that is coming evidence. And who is he? He himself is a police officer. So that's one. And thereafter, I am told that all the 161 statements which are there, they try to improve upon their case. My lieutenant argued that in the FIR 174 25, the allegations are.
Where is the reference to any of this, what you are saying in the court order? Order is mechanically passed, applying the other order.
The basis of this order, where in that order is put the material very quickly. Kindly see the order. Page 3, sir. Error 5.
Yes.
Considering the argument put forward by the learned counsel for the petitioners and looking to the fact that injured Vikas and Naveen in their statements recorded under section 161 CRPC have leveled allegations of causing firearm injuries against Vicky. The journal omnibus allegations have been leveled against the petitioners at the co-ed Sandeep and HON'BLE, whom indulgence of bail has already been granted by the court. Looking to the fact that the case of the petitioner is of far with them and they are specifically from the date of their arrest and after investigation charges has been filed and trial takes its own time to conclude and without expressing any opinion on merits and demerits of the case, bail is granted. Now please come to page 25. Now what is the prosecution case? Kindly see the identical allegations are there. Please see 25. And they have not challenged those to bail orders. Not 25.
Yes.
We are two brothers, not third line. What? We are two brothers. My younger brother Raman.
You are reading the affair.
We are two brothers. My younger brother Raman, aged so and so, on 19/11/23, there was a well version in my village in which Yashpal, son of Sumensu and Raman, both are not respondents of our village, had an altercation with my younger brother Raman. Yashpal and Raman started having a grudge against my brother. Now here Umbarkar's name is not there. He is an 84-year-old grandfather. And then on 28/11, there is no mention of even of incident of 20th of November, which according to them is not motive to commit this crime that it led to an enmity.
Fair is not the encyclopedia of the prosecutor.
My brother Aman had gone to village so and so in a wedding with his friends Naveen and Vikas. My brother Aman was dancing on DJ with his friends Naveen and Vikas. While dancing on DJ, Yashpal and Raman got into an argument with my brother and his friends Naveen and Vikas. He's not even there, present there.
He is not real brother. That's why he's fine that
he's not eyewitness. He is cross-examination, sir. My brother Aman and his friends Naveen and Vikas were assaulted by Yashpal. This is important. By Yashpal, Raman, Sanjay, Kulwan, and Yashpal and Raman grandfather Umbarkar. This is the rule attributed to them. Now I read further. And Yashpal's brother-in-law Sandeep, son of so and 4 or 5 other people, and then suddenly shot within the will. This is the argument.
That is the overtime. But the argument is Vicky or Vikas alias this Katrus fired is hired at the behest of these two, your clients. So this is only the individual overtax.
And I'll read the statement. They have not, if the investigating officer writes a fiction, would the Honorable High Court is obliged to not believe that there is the material of conspiracy? They are just randomly that story.
You may have a case in trial on section 10 of the evidence, but you want to know before the eyewitnesses are examined in 3 months in a case of this nature, you get bail on an absolutely untenable order.
Please see the two eyewitnesses because this information is not even present there. and kindly see if the rule is different. Please appreciate it. Not 6 lines from the top. Many others from the village were dancing near the DJ. We not reach the injured witness. I, Aman Yadav and Naveen also started dancing. While dancing, Aman and Raman accidentally touched each other. So there is no provocation. Over this minor issue, Raman started fighting. Fighting with Aman Yadav. Immediately, Raman's cousin Jaspal, who was not present there, began fighting with Aman Yadav. When Naveen and I tried to intervene, suddenly Jaspal, brother-in-law Sandeep, Kulwant area street, Ritesh Sharma and Dhula Pandey. My lord, please mark it. I'll do the investigation. And the boy wearing glasses all started beating us with slaps, punches and kicks. Role is changed by the injured victim. Suddenly the boy wearing glasses whom Jaspal and Raman were calling cartoon fired at us in an illegal manner. Plus, so far as the two accused who have granted bail earlier, my lord, kindly appreciate the role is changed. And my lord, kindly also appreciate the second other eyewitness. The statements are verbatim, and now kindly see page 138 of the charge sheet. He has specifically named a person, Dhula Pandit, also is read. Now kindly see 138. Error 10, page 138. Level 9, error 10. The charge sheet says, it was established that Nirmal alias Dhula Pandit was not present at the time of firing accident. So, all I say is this, straight away, so far as this part, part of charge sheet is concerned, there is no protest petition till date filed,
No, you deal with 136, which was read.
136, I'll read that. Para 7, para 6.
Para 6 you start.
That the marriage procession of Sahib, son of so-and-so in village, had traveled around 78 meters from the school gate to go to the house of the bride at about 9:30 p.m. At that time, Aman Yadav, son of so-and-so, his companions Navi, Vikas, Dinesh, of Satyanarayan, resident of so-and-so, along with Raman, son of so-and-so, Jaspal, brother-in-law of Jaspal, Sandeep Kumar, Vicky, Nirmal alias Dhula Pandit of the HP's party were also dancing. And then Raman, son of Sanjay Jaspal, son of Deepak, started pushing and shoving Aman Yadav under the pretext of conspiracy, but other members of the marriage procession separated the both parties. But so far as this evidence, these allegations of conspiracy is concerned, kindly appreciate, there is absolutely no even 161 statement. This is something which the High himself is reading. There is nothing in the entire paper which shows that they have been called, or rather they met. They are just referring to disclosure. Kindly see the best evidence against so far as this accusation is concerned, so far as prosecution is concerned, page 97. They say that 5 empty shells were recovered.
Just 1 second. Yes, 97.
Additional, 97. This is the evidence which they wish to connect me with. This is a disclosure. Please see this disclosure. This is almost 6 months of the incident. On 17/5/2024. In the presence of so-and-so, provided information according to 27 of the Indian Evidence Act, he walked in front of the investigation officer so-and-so and police chief to his residential premises, entered a room with the courtyard and presented 5 empty cartridges extracted from a plastic bag behind books in a cupboard on the northern wall. He stated that these are the same empty cartridges that were fired on November 28, by my
later state whether the recovery is believable, not believable, but that is the later part. But Mr. Counsel, the observation of the court that you are at par with other 2 accused persons who have been granted bail is itself an erroneous observation. The case was that, see, ultimately it will be the later part of the trial, but the case making distinction between those two persons, and those two persons, they were participating in the fight. You are the person brain behind the attack and the hiring of that killer, contact killer. Even just now you read, look at the way, page 30. They were just finding out some reason to start quarrel. Page 30 says that they were just minor, while dancing.
Let's see 30.
Minor issue, and immediately Ramans picked up that issue to start fighting. And immediately that was probably a signal. The higher contract killer opens a fire. This is the story as you are trying to submit is not as simple as there was some quarrel in the marriage ceremony, dancing was going on. Page 30, reading it, you read it slowly, it shows that they're waiting for some reason to start the fighting. And therefore, the observation of the learned judge of the High Court granting bail, they are just very casually dealt with. And you were not available with the agency for nearly 5 months, 6 months.
Time will not fall. Implication itself could be a ground of abscondence, and then I surrendered. That was an argument. And then 3 months. And my lord may kindly see, so far as this eyewitness, so far as the informant is concerned, he has already been examined. I have his deposition. And now prosecution witnesses out of those 3
witnesses are yet to be examined. Injured witnesses are yet to be examined.
Only one, the other complainant who is not eyewitness, he has been examined.
Let the state not tell the court. The court summoned them. They did not turn up. And who are those? One of them himself is a police officer. There is no question of intervention. There is no question of tampering. He himself is a police officer. Mother, it is coming up on third. Not kindly see the deposition. The informant himself says that
he can't be bail. He can't be on bail during the trial. Then in High Court also he'll say that he was, then again get a bail in High Court. He's the main accused. He has to be.
Heard learned counsel for the parties. Orders reserved.
Well, there's just one judgment on similar lines of charge.
They have referred to a judgment in the counter about prima facie, usual prima facie Amar money.
In fact, your lordships recently have said in Kanhaiya Prasad that cryptic orders granting bail in serious offences ought to be set aside.
The main accused cannot be charged.
No material super conspiracy. The material of conspiracy.
Well, next page, page 2, second para, first para. Our attention has been drawn to the charge sheet which refers to the detail of investigation undertaken pursuant to the homicidal death of Dinesh Kumar by 2 sharpshooters who had come on a motorcycle. The evidence relied on by the prosecution relates to the motive which is mentioned in FIR and the call record, the presence of 3 accused, this at different location at different point of time. Next para, as per the prosecution, JV was providing information about the location of Dinesh Kumar deceased to Satya Prakash on his mobile, which was then being communicated to the sharpshooters, namely Yashpal and Sachin. In support of the aforesaid position, the prosecution also relies on section 8 of evidence on the basis of statement made by Satya Prakash, which has led to the arrest of Yashpal, and weapons of offense was stated that 3 accused, and this has suffered incarceration for about 1 year before they were released on bail. We have examined the reason given in the 3 orders granting bail referred to above, find that they do not take into account the factors and evidence which were mentioned in prosecution of the charge sheet along with material produced and relied upon, keeping in view of the gravity, the period of incarceration undergone by 3 accused and stage of trial. We feel that the High Court was not correct on enlarging it and that cancels the bail.
And AB is not correct.
Yes. Lord, may I also place a judgment Lord on this, Lord? This is Lord, Lord, and this is a case, Lord, a murder case where anticipated bail was granted. And not the ground I am making from the context which I am saying to which day that The two eyewitnesses, the injured eyewitness, a person by the name of Gulapan in their statement. My lord, kindly continue what I am saying.
Let him finish. Mr. Bandari, you have had your say. He's the one facing the heat. Let him, you go in your own way.
I will not take.
You place that authority. Mention what you want to say and place it also.
I will the utmost respect this case that once there is a delay in FIR of your funding, the informant, despite the presence of so many people, kindly appreciate in the context, it's a marriage procession which is going on. There is no eyewitness who will not, who the one who has seen this is not the stripe of the FIR. Now, so far as two injured witnesses are concerned, they have named one such person who investigating agency found was not involved in the office. What does it convey? That it creates a doubt in the entire statement of that particular witness. But at this stage of 161, it is not been examined.
Mr. Purohit, good name. Mr. Purohit, you may have a good case on trial, but at this stage, keeping so many factors in mind, this is not a case where you can be at large at this stage.
These witnesses, my learned friend, and the then third is the date. My lord, please see, they are not even appeared despite summons by
That itself has other implications when they have not appeared. You give us the judgment. Give us the judgment you want to cite. If you have got one copy, no problem, you give us. Do you have a copy?
I do have.
This is the famous anticipatory bail case. After this, Sushil Agarwal has come. I was amicus in that. Siddharamappa Maitre. From Solapur. Solapur, eh? Yes.
The court must evaluate the entire available it's very careful. The court must also carefully comprehend the exact goal of the accused in the case. The cases in which the accused is implicated with the help of section 34 and 149 of the penal code, the court should consider with even greater care and caution because over implication in the case is a matter of common knowledge and concern. Now, I am trying to appreciate an 84-year-old man. Two eyewitnesses, FIR, who is not present in the name, and you have belonging to the statement of the injured witness. The name of Overcast is not there, and that
anyway, that's why, as my learned brother very rightly said, ask Mr. Bandari, that bail order, even they have not. Problem is the two of you being at large pending examination of eyewitnesses, and with your conduct of absconding and then surrendering late and getting a bail order saying that you are on par with the others, and a plain reading of that order says the main role is attributed to you. That is why you steered clear of that order and placed all the material.
Their grandfather who is not involved, even as I said, that could be one of the reasons they were responding. Please appreciate. He died for 3 months. So please don't consider abscondence as a ground.
We will not put it only on that. We will not put it only on that. You have done your very best, Mr. Purohit. Thank you very much. Thank you. Yeah, we'll work out. Even in the other order, it is said that.
There is absolutely no critique of
Stanford, they may be take the file fresh in case if the change in circumstances or the trial gets prolonged for reasons not attributable to the accused. Okay, last part. Okay, thank you very much.
Consider that.
We will keep it. We'll keep all that in mind. We'll keep all that. No, we are going to keep that in mind.
Please, brothers. Let's
Yes.
time for the victim petitioner. Yes.
Before Sir starts, considering a short 1 week's accommodation.
Why?
So he is running from high fever and the arguing council had to travel urgently overseas, your lordships. I deeply apologize. Just a short week's accommodation.
This is POXO, no? And there are two matters, isn't it? One is that Sarvari, what is her name?
Shweta.
That's a lady, is it?
Lady.
And the second matter is?
Ashish Kansal.
Ashish
Another
Kansal.
accused is inside. Shekhar Kansal. Three of them. Shekhar was a tantric lords basically. He's a.
They were enlarged on bail. How long had she undergone first one?
5 months. Around 5 months.
5 months.
4 months, 26 days.
And the other accused?
The same. Even the prosecutor.
Who's not available today?
Arguing council and the AO.
Who's that?
Mr. Rajesh Anand is the arguing council and the AOR is Mr. Naksh Bundela.
On behalf of Sister Rajan. At the request of the current counsel for the second respondent, short adjournment for 1 week is granted. List the matter next Wednesday. That will be third. No, third will be Saturday, 4th, 5, 6, 7, 7th May.
Lordship, we have attempted to receive the additional copy of the additional documents filed by the petitioner.
Whatever, I'll just furnish it because next week it will be better. Let's make clear that no further adjournment will be granted.
Obliged, your lordships.
Let it be high up on board. Let it.
No, it already comes as a bail matters come on top. Even today it is 2.
Yes.
That bail matters top. Yes.
Please, your lordships. This is a
Yes, Ms. Uttara. What is this matter?
This is a suo motu proceeding instituted by this court to expedite the trial and investigation of cases under the POXO Act. So there's a note that we had submitted for the hearing on 5th of November.
What's your lordship to understand the matter? Your lordship will
Just hang.
25th July 2019.
No, are there any orders, urgent orders for today? Because this bench is.
Last time when it came, madam, the majority things are done. Practically to direct to set up the POXO court at East End, and there are some difficulties. So,
Madam Anand,
There were directions passed by this court in 2019 to have exclusive POXO courts.
no, what I see is.
60 days.
No, what I see, Ms. Uttara, is series of proceedings with sister presiding. There's a sequence going on. So we'll do one thing. Keep it next Wednesday. 7th, so that you don't delay. Because matter has gone on for some time, and I get to know from brother that sister has something in mind. So. It's the matter on self.
Wait.
Yes, Mr. Bhatt.
Just give me 1 second.
Yes, you catch your breath.
Come up last week, Lord.
You catch your breath. Yeah. You sit down for some time. You must have run up the stairs. You don't get to do that, no.
This matter had come up last week, Lord. Lordship had directed there's a quashing, pure matrimonial dispute. So I had submitted that nothing works out.
So sit down.
So I'm fine.
No, sit for 2 minutes. Give some water to him. The fresh glass, give fresh water.
Deeply obliged. Sorry.
The
2022
22-4 order of this court.
Directing the,
What happened after that?
no, Lordship directed the parties to be present today.
Oh, I see.
In the, yes, both parties are here now. 2018 marriage. Now, admittedly, I filed for divorce. They got the notice. Thereafter, this petition is filed. 498A. Initially against the father, mother, everybody, but charge sheet is filed only against the husband. So, Lordship, you can see the dates, some dates.
No, any chance of matter getting sorted out?
Ideally,
Did you all sit together?
Ideally, that is the solution, I must say, because
Once you have moved on, you see.
I tell you, Lordship, the background. He works in Kotak Mahindra Bank. She, I'm told now, is a lawyer. Her father is not a designated senior, but a very senior advocate in Allahabad. Brother, sister-in-law, both are judges, civil judges in Allahabad. So, background, they can sit together and sort it out. This criminal case, etc., it's not going to serve anybody's purpose. Which is why last time we made that submission, because it's ultimately a matrimonial dispute. 498 is there, but
Are you ready to sit and sort it out? You see, no, not compromise in the sense that, I mean, parting in that sense. You already parted. Divorce is already granted. No, not granted. Pending is it. So compromise doesn't mean going together. It can be mutual, going each other's way also. Reunion is one option, parting is the other option. But only if you sort out, sit together, you see, you're all well-educated people and the stage. So that is the tenor of the last order. I am just seeing the order. So why don't you sit with the mediator? So they'll be difficult to crash it across the board.
no,
In Supreme Court? In Supreme Court?
What happened under the pressure of litigation? Firstly, the quiet offer, you come with me, I will give, we shall give. Later on, he said that I will consult my parents. After consulting the parents, he came back that I have been advised by the parent that I want that. He is telling the mediation has failed, that he has not been fair. And mediation took place before the High Court, mediation took place before the Supreme Court. When the Lordship again offered for the mediation, I readily accepted.
Mr. Basant, the mediation is only a ruse to get the matter postponed.
What happened last time? Your Lordship is right. Once it had come here, it has failed. We made a submission last time or not. We made a submission saying that let's try once more, because I'll tell you, I don't want to read out Lordship the reason why living together does not appear to be. Lordship may kindly see the count. I won't read it. Parties are here. Please see the rejoinder. I won't read it. I'll just leave your rejoinder.
See, we don't want to look into dirty linen being washed.
I won't read. Lordship, kindly, why is a, I won't read it. Lordship, kindly see rejoinder page 12. Just see that. That's all. I won't read it out loud. Please read it. That's all. And in light of this, please see the order issuing notice passed by this Honorable Court.
Yes.
Now, the Lordship may kindly see the order passed by a Lordship on 19th January 2021. Again, I will not read, please read it. Parties are here. I don't want to read it out loud. That's the order issuing notice.
She is before us.
Again, and the dates Lordship may kindly note now. 12th March 18 is the marriage.
Transient and all of us have at some point or the other. So it's all human. The judgment of this court, irritating idiosyncrasies are part of everyday marriage life.
Yes.
So
No, I showed it only to a lordship that living together may not be an option right now.
that's also, she's also saying that.
Yes.
So if you happily part,
Yes, happily. I told him that if you are happily parting as a husband, he has to.
what is your instruction on happily parting?
My lord,
Moving on.
my lord, your lordship has seen the order by which notice has been issued. The allegations are very serious. Kindly see the FIR.
What was my response after reading that? You are there. First reading, what was my response? We're not going by that. She is here before us. So we are not going by that. You saw my response to him. So why don't you just sort it out and you are prepared only because we can't force anybody. We are not going by that order. We are not going by that order.
My instructions are whatever he will, whatever it takes, live part happily. No, there are no children. It's only both of them. He is now what 38 years old. She is about 34 years old.
You are based in Allahabad. So, good Supreme Court mediation, video hearing and physically if required, so too. Video hearing. If they require you, you come there. The parties have favorably responded to a suggestion from the court that an amicable resolution to the dispute be explored by referring the matter to the mediation center attached to this court. We propose to refer the matter to the Supreme Court Mediation Center. Let a senior mediator be nominated to handle the matter. Calendar. Let parties appear before the mediator on 5th May, 2 p.m. Parties are permitted to appear through video conferencing. Parties undertake that if the mediator desires their physical presence, they will make themselves available. Post the matter in July after receipt of the mediation report. Sort it out. Post the matter on 25th July.
My learned friend is saying maybe June, they may not be mediators, may not be here because of
Plus, I am putting it 25th July.
August,
all right. On 4th August or make it 8th August in court after receipt of the report from the mediator. But make a genuine effort.
Yes, sir. That's the only solution to this matter. I'm grateful, my lord, for the.
Thank you. And please don't go by even in the mediation, and keep aside all allegations because it's easy to make the allegation and very difficult to take it back. Yes.
This is also matrimonial disputes without allowing out of the Muslim couple.
Yes, Mr. Vijay Kumar, any chance? Ms. Shobha? How can it fail with the two of you there? Has to succeed.
Lord, the only issue was whether she had remarried or not, my lord. She had
that cannot be
mediator that she's not remarried, and we have produced documentary evidence, my lords, her nikah nama.
Something bizarre had happened after mediation failed, my lord. Your lordship directed them to file counter, my lord. Instead of filing counter, they filed additional affidavit supported by the affidavit of, I should not say this, but it had to be said somehow, the advocate on record affidavit. Court rejected this. Court directed him to file counter. Now counter is filed with one bogus document alleging that I got remarried, and counter is not supported by any affidavit. So my first or technical objection, my lord, that counter could not be taken on record at all.
No, what is the originating dispute?
Originating dispute means
How does it arise?
we got married in 2007 and within month marriage got dissolved through triple talaq. Husband was in Singapore, marriage took place in Bangalore. Husband went to Singapore, he was software engineer, and from Singapore he sent a message triple talaq and marriage was dissolved, my lord. Thereafter, I approached the trial court under Muslim Women Protection Act, my lord, for maintenance. Trial court awarded me either 25,000 per month or 25 lakhs lump sum. My lord, that was paid. Then he went to Madras High Court. Madras High Court granted a stay, my lord. Eventually, Madras High Court also dismissed the revision. Thereafter, they came before your lordship dismissed their petition. I came against those limited part of High Court order, my lord. High Court said that their allegation that I got remarried, wife got remarried, that was not proved. That was the finding rendered by trial court. That was the finding confirmed by the High Court. And despite that, my lord, High Court returned with the finding that maintenance is payable only up to particular period, 17th November 20.
Okay, they went and filed a miscellaneous application, is it? In the original order, you got 25,000.
25,000.
Open-ended order.
Open-ended order.
That SLP dismissed. That SLP was dismissed. So then they went back to the High Court. Then how did it arise then, this remarriage issue?
You know, they went to this order was passed by trial court. They went to High Court against this order. High Court initially granted a stay, but eventually High Court dismissed their petition, revision. Against which they came before your lordship. Justice Shanta Gondur Bech, my lord, dismissed the SLP, but issued notice only in respect of lump sum settlement payment.
I see.
On merit, it was dismissed, my lord.
Today it's only on lump sum settlement.
Today only on lump sum.
Before trial court, this factum of a remarriage was not known to the parties. When the
No, my lord, there is another aspect.
When the revision was pending before the High Court, they came to know and documentary evidence was handed over to the High Court. On that basis, the High Court restricted the order. So on the sum awarded, the maintenance amount is 25,000 rupees, was open-ended by trial court. Before the High Court said...
So he is against that order restricting the period.
Yes, because he says she is not remarried. So the question is today whether the factum of remarriage is proved or not. If this honorable court deems it fit, my lord, may send it back to the magistrate court, my lord. Let him take a position on that. Because this is an issue of fact. I have documentary evidence to prove that she is remarried. He is denying that.
Look, kindly go through page 3. One paragraph finding, not page 3 of the impugn order. Impugn order of the High Court. Only 2 paragraphs. 1 paragraph. Page 3. This first one. Page 3, paragraph 8. Respondent had denied, I was the respondent. Respondent had denied the second marriage. On a reading of the entire material, it is seen that petitioner here was working in Singapore as software engineer. Presently, he is working, my lord, in England. He has wantonly not produced the salary certificate, my lord. Despite trial court order, despite High Court order, my lord, he failed to produce salary certificate. Considering the present day cost of living, the order passed by London magistrate is not excessive. This court doesn't find any perversity in the order passed by magistrate. And thereafter, the next, my lord, operative portion, which does not jail with the court finding at all, my lord. Order is confined to 17/11/2013.
No, but how does this order work? By order to this former wife respondent till 17/11 only.
17/11. Doesn't date this finding, my lord.
No. The petitioner is directed to pay the maintenance amount as ordered by the judicial magistrate by order dated 12/12 to till 17/11 only.
But state did not, has not passed this order, my lord. But it has not passed this order. High Court restricted it.
I know. From that date till 17/11.
This is the date on which
Your client is in England now. Foreign.
As compensation is concerned, my lord, that is why we were referred for mediation. My client was willing to pay her over and above whatever was.
So, but
they are claiming that he should pay for the rest of her life. She's remarried, my lord.
We should be reason. Already divorced, my lord, divorced to place.
So I don't have to take money and go away. See,
already there's no problem.
They are offering some money.
They have refused before Supreme Court mediator, my lord. They have refused.
My lords.
How much?
Whatever falls to my lord, I put it to my client. He is also.
What was the offer made?
Today, what, my lords, I have calculated, my lord, in all, as per the order of the High Court, we are obligated to pay 13,15,800. Well, after what has already been paid, it leaves us with an obligation to pay 9,65,833. That is the respondent's obligation. Now, whatever wants, my lord, you can take.
No, that is the entitlement.
Yes, ma'am.
Because this, you are not in appeal against this order. Dismissed. So what is the extra you are paying?
There SCP also, my lords, if my lords kindly permit me to address, make a submission, humble submission. They are only aggrieved by the fact that it is not for the rest of her life. On the quantity what was paid by her, 25,000 per month. What was paid by her has been granted. She says now, let it not be restricted till 2009, my lords, 2030. Let it be for the rest of the life. How is that possible? And that decisions.
The counter they are saying 13,000.
Whatever.
Mr. Jain Muthraj to have a sitting mattress from Asia.
Yes, ma'am.
Mr. Muthraj, you do some service in the middle of your conferences. After hearing the parties, after hearing Mr. Vijay Kumar, Leonard Senior Advocate, and Ms. Shobha Ramamurthy, Leonard Advocate for the respondent, we feel that the matter should be amicably resolved by payment of an appropriate lump sum amount by the respondent to the petitioner to help the parties in arriving at a reasonable settlement. We requested Mr. Jain Muthraj, Senior Advocate, present in court to have sittings with the parties. Parties have also agreed. Mr. Vijay Kumar, I am recording. Parties have also agreed for the said course of action.
We were never against it.
Learned counsel for the respective parties have agreed for the course of action that the court proposes to adopt. Let the matter stand over to May 19th. No, I'll give you that longer weekend so that you can. I thought there was one longer weekend coming.
Don't have it after vacation, it may not be over.
No, May 10, 11, 12 is there. May 10, 11, 12 is holiday. 12th is holiday.
12th is holiday.
So it will help in that week to say. 19th of May.
Both the parties are out of Delhi, my lord. She is in Chennai, I believe, and he is out
Video.
Video conference, through video conference, my lord.
Yeah, Mr. Jain Muthraj, who's agreed to mediate the dispute, shall interact with the parties either in person or through video conference. Post the matter on 19th May for further consideration.
My lord, meantime, we may place a rejoinder, my lord, that this counter should not be.
But then don't make any.
No allegation at all. And one more aspect, my lord, very crucial aspect. Kindly consider the asymmetry situation between the party, my lord. I'm eking out my living by tuition. They are running a big IT professional consultancy in England, my lord.
All that is.
Engineer, and unfortunately, he had also died, my lords. The fact of the matter is today, she needs some help because her second
marriage. But they are surviving on basis of peace, my lord.
Marriage, my lord.
Anyway, it will be sorted out.
That's true, yes, my lord.
Very fair offer by Ramamurthy. Just sort out. You also don't,
No, my lord. I'm always in favor of settlement, my lord.
Stretch your hands too vast. So. Yes.
Item 20, we have received the NOC on last Friday, my lords.
Now, what is the matter?
We didn't receive the SLP, my lords.
Who is now entering appearance?
Advocate on record, Byron.
Actually, he has already entered appearance.
My lords, last Friday only we have received the no objection certificate. We did not receive the SLP, my lords.
Returnable after 4 weeks. Let us see what the matter is. Let's have some idea we should have before dealing.
Let's kindly keep it after vacation.
It's a criminal appeal. POXO,
376.
341, 376, 5062, 109, 3A and 4 of POXO. What is the sentence? Have you surrendered?
Yes, my lord, surrendered.
All right, learned counsel for the petition states that
It's after vacation. my lord.
they have entered appearance only yesterday and is yet to collect the full set of papers. The request is made to post the matter after June. Post the matter in the 3rd week of July.
Much obliged.
We can give a date also. Post the matter, 1 minute, post the matter on 22nd July.
Much obliged.
Please, my lords, I apply for the petition in the matter, my lords. I filed my rejoinder to R17's counter affidavit, my lords.
Yes.
I have to file my counter, my lord. I am for the respondent number 2.
Raju is for?
I am for the main, that's number 1, my lord, number 1.
CBI. What is the matter about?
My lord, the matter is this, my lord, there were 2 FIRs, the CBI filed 1 charge sheet. He says that the incidents are different, therefore you should have 2 separate charge sheets. That's the sum and substance of the matter.
There were 2 incidents, my lords. I may submit, my lords. One incident was on 10 and the second incident was on 21. And my lords,
But was it part of the same transaction?
not same transaction. It's not.
It's our case that part of the same conspiracy, same that's our case.
Part of the same, like 219, etc. will come in.
My lords, that power, in fact, my lords,
220.
20. My lords. The power, my lords, that was with the magistrate, not with the investigative agency, my lords. First,
Anyway, it has to be considered. What is your request?
my lord, my request, I filed my rejoinder to R70's counter affidavit, my lord. That should be on record by tomorrow, my lords. I filed it yesterday, my lords.
Learned counsel for the petition state that rejoinder to the counter of R17 has been filed. Let the same be placed on record. Post the matter next Wednesday.
Grateful.
My client is in jail. My client is in jail. My lord. We have to file a counter. Ultimately, minimum 2 weeks. My lord, because he has to get such.
All right. Mr. Raju, 14th will suit you? 14th?
Yes, madam. 14th will suit. Grateful.
On 14th. In the meantime, let pleadings be completed.
Grateful.
May I be given liberty to file my counter to his
Whatever it is, have to be completed because this is holding up some trial. So let us finish the matter. It's a simple matter. We have to only see the transaction and decide whether it's part of the same transaction.
Lords, I just wish to make one clarification. Lords, in the last order, it has been recorded that I am appearing for R14. Lords, I have no section for R14. I am only appearing for R4 to R13. Lords.
R4 to R13, is it?
Lords. I filed Pakatama 478. Lords, I'll be filing.
Where is it recorded?
Lords, the last order it records at R14.
Yes.
Yes, Lords. And seeks time to file Pakatama on behalf of this R14. Lords, I have no section for R14. Lords. I am entering appearance already attended.
So who is for R14 now?
There is no service report as such on.
Unserved.
Huh?
Unserved.
It is unserved, madam. R14 is unserved. The office
Unserved or service not complete? What does it say?
Unserved with postal remarks, insufficient address.
Oh, insufficient address. Then you must take steps.
I believe the last date, someone appeared. Therefore, I thought.
Mr. But what's your name?
Abhinay, Lords.
Miss Muskan had appeared last time.
That's what I'm saying, Lords. So,
Mr. Abhinay Leonard Counsel submits that in the last order of 4/2/2025, where his colleague Ms. Muskan had appeared, the appearance was really for R13. However, the order inadvertently records that the appearance is R14. It is now made clear that who is the advocate in record?
Lords, I am the advocate.
Mr. Abhinay appears for R13. R14, according to the office report, remains unserved.
Due to insufficient address.
Due to insufficient address. Where is R14? Amended cost cycle, is it? Yeah.
Yes.
Who is R14? What is the role?
He's a co-accused, man. He's a co-accused.
Witness to the sale deed of 18th May 2010. That pertains to the first RC02 matter, the first FIR.
Everybody is an accused, including the petitioner.
But earlier they were not
No,
joined.
just number 1 is also.
Earlier, they were not joined as parties. I said,
So you want him in the array of parties?
My lord, there's an order asking them to join because you can't.
Petitioner undertakes that service will be effected on or before 14/5/2025 on or 14. Let thus be given to the petitioner. You serve and come on this ground, it will not be urgent.
Grateful, my lords.
Let me say R4 to R13, that's my appearance. R4 to R13.
Achha, instead of 14, say R4 to R13.
Grateful.
Correct.
Grateful.
Yes, 22.
Please, my lords. In item 22, my lords, the bailable warrants issued have been executed. Still, no one has entered appearance. We filed the additional affidavit on the last date itself.
We'll issue non-bailable warrant. What is the office report saying in this? Let us see the order. Let us call the State of Madhya Pradesh order 398. What is 398?
Attempt to commit dacoity and robbery.
But dacoity. 7 years as a custody certificate is also petition undergone less than 7 years. So there was notice issued. Returnable after 8 weeks. What was the sentence imposed?
So the trial court had imposed 7 years under IPC and 1 year under the Arms Act to run concurrently. The High Court has reduced it to the period already undergone. That is lesser than 7.
Lesser than. There is no sub-minimum sentence, so even for special reasons.
398 is the minimum threshold.
No, normally there will be sub-minimum proviso for special reasons. That is not there. And where is the bailable warrant?
If your lordships has our affidavit.
He is at large. He was outside. He is released.
He was on bail. The High Court impugned order records that he's on bail.
Stand executed affidavit stands filed. Seen that none have entered appearance so far. List on 29-4. What is the office report in this?
Because the office report just indicates the.
Where is the affidavit filed by him?
Chips will have the affidavit of bailable warrant that was filed on 24/2025 by the state. The lordship comes to page 6 right away.
I have 18-4. Affidavit of 18-4. Page 6. Yes.
Page 5, my lord's last line, your lordships has that the accused Radha Bhaiya Gujjar son of so-and-so was searched by reaching village so-and-so. The accused was billed his own bond of 25,000 and the bail bond of Chandraban son of so-and-so was taken as surety. He was informed to appear before the Honorable Supreme Court on 22/4. That was the last statement.
In 22-4, what happened?
It came up before a combination of justice.
Take down. In this matter, by order dated 2nd April 2025, bailable warrants were issued against the respondent. Thereafter, the petitioner state has filed an affidavit on 18/4/2025 showing proof of execution of the bailable warrant on 7/4/2025, where the respondent was informed to appear before this court on 22/4/2025. A bail bond of rupees 25,000 has also been taken. In spite of the same, in spite of the said direction, stroke information, none appeared before this court on behalf of the respondent on 22/4/2025. Similarly, today also nobody has appeared. In view of this, we are left with no option except to issue a non-bailable warrant. Let the respondent be produced before this court on 13th May at 2 p.m.
That's the bail bonds were executed on the 6th, not on the 7th. The ledger is dated 7th.
All right, 6th instead of 7th. All right. Non-believable.
Yes, ma'am.
Execute through SHO, the state.
Yes, ma'am.
State to execute through the SHO, the police station. Yes, Mr. Philip. Yes, Mr. Yu.
Lord, I'm appearing for the state. Lord, I'm appearing for the state. Lord.
23.
Lord, I'm
Yes,
appearing
Mr.
for the
Luthra.
state. Yes, Lord, I'm appearing for the state. Lord, these are matters, Lord, of some seriousness, and therefore, Lord, we are seeking that they be heard, my Lord. Then, my Lord may consider taking them up, Lord.
What is the, with 20 minutes, a 282-page judgment certainly
No,
can't
not
be
today,
over.
Lord, not today, not today, Lord, not today. I'm saying, Lord, I understand, Lord, where would your listed
What
of
is the
any
matter?
amendment, Lord?
What is the matter? You are for the state, Mr. Luthra?
Yes, Lord, I am for this.
What is it about? Just give us a broad idea.
I take the worship, Lord. There are these personal the charges against these people, Punuswamy and death.
We are not able to hear you because of your Wi-Fi.
Lord, possibly my
you
wife. Lord, I must tell you, Lord. Lord, there is dispute over certain.
There's some network problem, I think.
Lord,
Yeah. Yes, Mr. Chaudhary, what is this matter?
Single murder took place in Madras, for which 10 people were arrested. Out of them, accused number 10 was made an approval. Accused numbers 1 to 9 were tried and charged. All 9 were convicted for that single murder. 7 people out of the 9 were sentenced to death for that single murder. The High Court in appeal acquitted all 9. High Court acquitted all 9. The state has come in appeal against the High Court's verdict.
Your Lordship, I
Deceased is one Dr. Subbaiah
as well.
Retired government doctor.
Government doctor.
Sir, I'll tell your Lordship very frankly, this matter will require consideration.
Yes.
This matter will require.
Admit it and keep it for hearing in due course.
Lord, would you no, Lord, I have a slightly different point of view. Lord, may I just say
More
this?
opportunity to
There is an urgency. There is an urgency.
My brother says one more opportunity to hear all of you and Mr. Chaudhary from Bombay.
I will not keep it.
Long time,
May I
Mr.
just say
Chaudhary.
this? Lord, may I make a request?
Yes, Mr. Luthra, you tell us, can we grant leave and fix it on a Thursday so that you can continue the hearing? Otherwise, this is going to get stalled on Tuesday.
Lord, may I just say this? I leave it to your Lordship, Lord. If it can be on an NMD for final disposal or for leave granted, but Lord, please give me a fix.
Your Lordship, if I may.
It's a matter of concern.
Your Lordship, I appeal.
Even if you grant leave, we will give about a 6 to 8 months gap to hear.
Lord, I'm saying that listed on an NMD, not July, August, September, whenever your Lordship can hear it.
No, Mr. Luthra, NMD, you have more experience. I have some experience.
No. I'm not. Your Lordship has much more experience. I'm only a newcomer to this court.
NMD, what will happen in this kind of matter is, it will be called out and adjourned.
All right, Lord, leave granted, Lord, keep it, Lord, in August or September, Lord. Matter has some urgency. There are some ramifications of this, Lord, because the kind of judgment is creating problems, Lord.
All right, leave granted.
And Lord,
Lordship, I beg to appear in the second SLP for the complainant.
Yes,
I am the brother-in-law of the deceased, and he was a surgeon, your Lordship's murdered in broad daylight.
No, we will hear you, Mr. Sheth. We will leave granted. Original records have come?
Yes, Lord, the report are here. That's why I said report.
You all got?
Yes, Lord.
Are to be translated.
Lord, the 8,000 pages, they're ready. Lord, the records are here.
All right. Necessary translation.
I thought records are translated already.
Or you will do it. State will do it.
Lord, we'll do it.
It's there, Madam.
Okay.
Lord, the translation is there. What is not translated?
Original records have already been called for. List the appeals for hearing. In the second week of November. So you
Yes,
have,
not high on board is the only request, my Lord. high on board.
Bit difficult to control high on board in November.
Lord, first 5 matters, Lord. I think Mr. Chaudhary will allow me this indulgence. Lord, state is concerned about this because it's a disturbing judgment, Lord. Would your Lordship keep it, Lord, high on board?
See, high on board, it's a 2000.
My Lord, it's a case of an acquittal which should not have happened. The trial court convicted. It's a matter of, my Lord will see it. It's a disturbing case.
Lord, Lord, I also
It's a November. Yes, we are granting leave, Mr. Logi, 282 pages. NMD won't work.
Lord, I agree, Lord, I have heard it. My suggestion is, if your Lordship can give me a fixed Thursday, Lord, in October, then we can start. Otherwise, November, Lord, will take it to December, etc. If my Lord can give me a date in October,
in fact, we are going deep into December. We are working till 19th December. We are giving now, all right, we'll give 6th November.
That's fine, Lord, that's fine. Very
6th
fine.
November. And liberty to mention.
Grateful, Lord.
Very grateful, Your Lordship.
Great.
I'm seeking 2 weeks time to file the rejoinder minutes. It's almost ready minutes.
Counter filed.
16th April 25.
Learned counsel for the petitioner prays for is granted 2 weeks time to file rejoinder. List the matter on 20th May.
I'm grateful minutes.
Grateful, Lord.
Lord Justice, but if I'm led by Mr. Ram Devan, senior advocate, he's held up in court. It's a part of matter.
I see. 25 Greenfield School, Delhi.
It is in relation to the on next week. It's APC to teachers, madam.
Southern Enclave Greenfields. It's
most of them are retired employees, my lords.
They are retired employees. They have not been given the benefits of 7 CPC, my lords, despite condition.
But Mr. Diwan is on his legs, so it will not be fair to. On the request of the learned counsel for the petitioner, post the matter next Tuesday.
Fixed date.
Next Tuesday.
Obliged.
All that the State Bar Council did was to refer the matter to the disciplinary committee, which has been stayed by the High Court. Now, the Bombay High Court has been merely admitting repetitions and staying all proceedings of the State Bar Council.
Why should a reference be stayed?
Exactly.
So,
does not say that there is any reason to believe. And what have I done? I have a counsel who had identified a party in a compromised deed. This gentleman who the complainant says that my father was a partnership firm, was not even a party to the father's partner or partner. He had already passed away before the consent term was signed. Now, after making this commitment and saying that I am instrumental in repeating his rights. And this he has been served is not even appearing in the suit.
but when there is a hierarchical remedy, can you interdict it by what exceptional circumstance High Court may do? You can say that to the disciplinary commission.
In this case, the matter has not been disposed of as yet. The High Court has simply staying the proceedings. You file an application for us and tell us what prompted you to refer the matter to the disciplinary committee. Why not? I will not dispose of the matter.
You tell me, is there a prohibition case made out that Bar Council cannot hear?
No, that's not the case.
Otherwise, you see, are you going to want a certiorari for mere reference to disciplinary committee? Already the complaint is Bar Council is not referring enough matters.
We see the facts of the case. Not what has happened. The High Court has gone into it, has not done it lightly. It is not a case where the High Court is simply interjecting the functioning of the.
Anyway, today it won't be over. You may have to get some cases on how.
Statute is very clear.
No, 226 should not be invoked, or 227. These kind of matters at the intermediary stage, let the matter be taken up next Tuesday.
6.1 and 26.2. 26.2, if I could be granted about 3-4 weeks to put in a counter. Because there's some subsequent development I want
No,
to
you make a request next week. Make a request.
I just pointed out how perverse this order is. What has happened is, it's not my client.
The complainant says that this affidavit is there is a person committed in that affidavit. I have to identify my client. The other side files a complaint.
There is a reported judgment of this court, 1984, I think.
Yes.
Huh? No, Dabholkar is 76, Bar Council of Maharashtra. That is on whether other misconduct will be covered in professional misconduct. That is where soliciting briefs in the esplanade courts. No, this is where, same case. See, client walks into the chamber. I don't know, he says, I am X. That's what your case is.
What will happen? Assistant government pleader. The complainant files a suit in the Bombay High Court. As an assistant government pleader, the educational institute which files a reply, my client files a reply, I identify my client in that reply. So there are two assistant government pleaders. One, Mr. Pandit, who says true copy on all the annexures. And at the last, I identify my client that this is my client. There's no dispute about that. And that reply is filed in the chamber summons.
That is made subject matter of a bar council inquiry.
Yes. Saying that how did you make the complainant?
So your case is it's neither misconduct, professional misconduct or other misconduct. No misconduct. All right. You say that let pleadings be completed. List the matter on 20th May. But in the meantime, you file.
The other order has come. Now in fact, the trial court said there is no conflict. The affidavit actually.
All right. You show that if it is such a gross case, then maybe 226 to 27.
Right.
But let's see where Chidambaresh may have his own story.
Suggestions which the complainant is taking in 26 is not even entered appearance despite being so. That itself tells us nothing.
Submission bar council may have some question of law to agitate and it should not be 226.
No, we will examine. We'll examine it.
Just speak the question of law.
No, not now. Not now. You wanted to file a counter. We'll see your counter. No, maybe you are right. Let's have a look at it. If on a reading of the complaint filed by him,
yes,
there is absolutely no semblance of misconduct, then why not 226? We'll see.
That's the point. In fact, this is the trend of litigation, browbeating the counsel of opposite party. That is exactly what the act is pointing at.
No, we will see that. We'll see that. 20th May. Let the pleadings be complete. We can't deny him a chance to file a copy. 27. Yes, Mr. Booth.
27 for the respondent, Your Worship.
Lord, Ms. Bhatti is leading me, Aishwarya Bhatti is leading me in this matter, Lord.
All right.
He is on our legs in another.
List the matter. What is the matter about?
Lord, it's
Lord, this is a regularization matter, Your Lordship. I am appearing for. They are the labor class 4 from Kargil and Leh, Your Lordship. I am appearing from Kargil, Your Lordship, in this case.
Oh, I see. Oh, I see.
They are suffering, Lord, for 30 years. They are working in this FCI department, Your Lordship. Order was passed by the LPA to regularize their service, Lord, after 30 years of service, Your Lordship. They was appointed to